announcement.
Thank you, Your Honor.
Thank you, Charlotte, if you would.
This hearing is the matter of case number CFI-024-2021 and CFI-059-2020 before Justice Roger Giles. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. Sunset Hospitality Holdings Limited is represented by Al-Tamimi and Company. Lead counsel is Mr. Patrick Dylan Malone. Fixed Sense Management LLC and Hana Habib Mansoor Habib Herz are represented by Abdul Hakim bin Herz Advocates and Legal Consultants. Lead counsel is Mr. Mashood Iqbal. Thank you.
Well, gentlemen, I've read both your skeletons. I've read the witness statements. I think I have a fair grip of the issues, and I've also read the vital documents themselves, but the witness statements are not particularly user-friendly, and the facts will become a little clearer over the course of the oral evidence, and I will need your assistance, I think, in the end to understand just what each of you says really happened so that I can make a decision. So I make that plain. The witness statements are not as they should be. So, are there any housekeeping matters before I ask Mr. Dylan Malone to open? It sounds like not. Well, Mr. Dylan Malone, you're opening then. Thank you.
Thank you very much, Justice Giles. This is a case in which Ms. Herz is a nominee shareholder of two Dubai companies that are part of the Sunset Group. And she holds these shares, being a 51% shareholding in each of Black Tap and Brick Oven, under nominee agreements, which it's common case were entered into for the purposes of meeting Article 10 of the old federal law. Federal Commercial Companies Law. I'm sorry, I just have an echo here. I hope that can be solved. Her company, Ms. Herz's company, Fixed Sense, has a separate service relationship with Sunset Group. And the success of that relationship led to discussions for some equity in Sunset RAC, which is effectively the holding entity for these entities, and for an adjusted fee structure, if in effect a flat fee. And that flat fee was agreed to be a substitute for annual payments under the nominee agreements. I'll come back to the dates and the sequence presently. And these adjustments were either anticipated or fully known to the parties when they entered into the nominee agreements. The nominee agreements were entered into in December 16 and May 17, respectively. And you'll see that there were what were described by the parties as symbolic amounts of 10,000 dirham per annum and 72,000 dirham per annum, which in one piece of graphic evidence, Ms. Herz describes as having put the nominee agreements into the back of her filing cabinet on the understanding, as was indeed the understanding of my clients, that these symbolic fees had been substituted or were due to be substituted by the flat fee arrangements that were put into place under the Heads of Agreement and the Shareholders Agreement. And I'll come back again to the dates of those. Those two agreements, the Heads of Agreement, under which effectively there was an umbrella agreement described by Mr. Iqbal as a mother agreement in some of his previous submissions, were the working model henceforward for the arrangements between the parties, including the nominee services provided by Ms. Herz. Those agreements were entered into in April 2017, although they were effective and agreed to be effective from the 1st of July 2016. And the impact of those arrangements on the nominee agreement symbolic fees was that effectively they fell away. Indeed, they were always understood as being non-operative. And a total sum of about 3.1 million dirhams was paid by to fixed cents under the HOA and shareholder agreements. And that includes for all the periods during when the nominee agreements were in force, and indeed even before, because it operated from July 2016. Now, separately, fixed cents is under the shareholders agreement in respect of Sunset RAC is a 2.5% shareholder. She's from that agreement. She was always fixed cents was always treated as indeed a 2.5% shareholder, and a previous issue on the pleadings has fallen away in that regard. There is also, as you will have seen, an option for a further purchase of a further 2.5% shareholding in Sunset RAC, and that was to be exercised on one or other of various periods. The period which is critical in this case is the period based on the 2018 audited financials, and the money to be paid was pre-agreed in the shareholders agreement on the basis of a formulation based on EBITDA for the financial year, for the 2018 financial year. And there's an issue on that, as the court will have seen. The 2018 audited accounts were provided on the 5th of September 2019. However, there was some confusion on the other side. There were certain questions being asked about entities that didn't exist, and certain irrelevant questions from my client's perspective that were incapable on our case of impacting the EBITDA. And the net result was that the option was not exercised within the relevant 2-month period.
On your case?
On our case.
To give me an idea, what would have been the price payable for the extra 2.5% if the option were exercised, in very broad terms, just so I get
Can I come back to you on that, Justice Giles? To be honest, I have never been instructed on what that would have been, but obviously that's an easily determined question, and even by the end of the time I'm speaking, I'm sure I'll have the answer for you. Because our case is indeed that it is readily identifiable. The EBITDA is the net earnings for the year minus the costs, and then you've got a formula based on 3 times that. So I will have that number for you presently, I hope. So the case obviously centers on the requests by my clients to Ms. Herz to transfer to Mr. Sandal, who was a UAE national, the nominee shares. And those requests were made on the 24th of November and the 10th of December 2019. Those requests were not respected or explained. There was silence, and despite reminders, and there was a termination of the HOA agreement then led from that. The fundamental breach of the obligations, the solemn obligations under the nominee agreements led to the exercise of a right of termination under a cross-default clause, whereby the heads of agreement was brought to an end with effect from the 11th of February 2020. And more recently, as a result of the change in the law, whereby it's no longer a requirement in respect of companies within this category of activity for a nominee arrangement to be in place or for shares to be held by a UAE national. There have been further requests on the 22nd of February 2022 following the obtaining of approvals for the transfers not to be made to Mr. Sandal, the UAE national, but to be made directly to Sunset RAC and Piatura, respectively. And just to point out in that regard, the most recent amendment to the Federal Commercial Companies Law provides for a 1-year period, as indeed the previous amendment did, within which arrangements like this should be tidied up. And our client has done that. With effect from the 2nd of January 2022, there is this transitional period, and I'll bring you in the course of the closing, or necessary in the course of argument and evidence to those provisions, whereby from the 2nd of January 2022, there is an opportunity to clear up these arrangements by the 2nd of January 2023. So the case began, Justice Giles, as you will have seen, simply. There was a blank refusal to transfer the nominee shares, and no explanation or excuse was hinted at. It began life, as you will have seen, as a Part 8 claim, because we viewed it as, and my client viewed it as a simple application of the duty under Common Clause 5 of the nominee agreements to transfer on request. Nothing could be simpler. But in response, in the defence, which was delivered in April 2020, a number of ingenious legal points were raised, and a claim elevated to the status of a fraudulent misrepresentation allegation that Ms. Herz had expected at the time of entering into these nominee agreements that other arrangements would be entered into. And there was no mention at this time of any purchase. In fact, the thrust of Ms. Herz's evidence in April 2020 and of her pleadings was a complaint that she didn't have a sufficient interest in the businesses, as indeed she said she was promised. And so, to be clear, what was first asserted in defence of the 024 claim was in effect a three-card trick, that because the nominee agreements on Ms. Herz's case should fall away, either by reason of all these multiple legal arguments, or because it should be vitiated for misrepresentation, that she would then, by default, become a 51% shareholder because the nominee agreements would fall away. And as we point out in our skeleton, that is an absurd proposition, that somebody subject to an express trust under Clause 5.2 of the nominee agreements could somehow magically become the 51% shareholder because of the inoperability of the nominee agreements on the grounds alleged. So the check was raised for the first time in the particulars of claim and the witness statement filed in case 059 in July 2020, 8 months after being first requested to transfer the shares. The court may ask itself why, if Ms. Herz paid a check in June 2014 for the acquisition of these shares, that she didn't mention it when she was asked to transfer them, and that she didn't mention it in her defence in the 024 proceedings. That was then picked up again. The check then fed its way back into the counterclaim, which was not lodged until September 2021. Despite all of that, it's our case that it remains a simple enough case. There's one factual claim. Sorry, I'm getting an echo now. There's one factual claim. So I'm still getting it. And you'll hear
on the screen. He should take himself off the screen in some way.
Is somebody? That's better, I think. There's one factual claim of which we've just mentioned, and that you will be hearing evidence from Mr. Gonzalez, and there's obviously a stark conflict of evidence on that. And then you've got these cascading, what I call three-card trick defences, which are somewhat muddled, imaginative for sure, but we say for all the reasons we've identified in the skeleton that they fall away. The counterclaim really depends on the misrepresentation claim. In our case on that is that there was no misrepresentation, no misunderstanding between the parties. In fact, it's clear from the evidence that they knew exactly what they were contracting for. And there's no false statement of past or present fact, something that you yourself in a judgment of the DIFC Court of First Instance have addressed, that it's a fundamental requirement for misrepresentation in DIFC law or English law that the misrepresentation must relate to a past or present fact. Here, on the fixed sense party's own case, it was an expectation on the part of Ms. Herz that certain other agreements would be entered into, which she said were disappointed. But on our case, we say those expectations were manifestly met by entering into the HOA and the heads of agreement and the shareholders agreement. They were the contractual arrangements that were contemplated by the parties, and in fact known by the time the Brick Oven nominee agreement was signed.
Now, when you say manifestly, this is one area where I was really unable to follow what the evidence might say about it. I really couldn't discern any evidence which, as a matter of evidence, supported your last statement. So I trust that one way or the other I'll be assisted to understand that.
Yes, indeed.
Yeah.
I think Mr. Gonzalez has explained, and obviously he'll be giving evidence today, that the flat fee arrangement and the acquisition of equity by Fixed Sense were the arrangements that were negotiated from a period from when a dissatisfaction was expressed in about November 2014 that the sponsorship activities should lead to something else. That was expressed by Miss Hertz's husband. And that from then negotiations took place that led eventually to these new arrangements. But there'll be plenty of evidence on that, and I hope we will satisfy you in that regard. What is, though, striking about this case, and I think it does, from as compared to some other cases, is that the parties put their faith in their written contracts. The contractual basis of the parties' dealings was always important to them, both as they began and from the very first overtures from Fixed Sense to our client. They were concentrated on contracts as being the touchstone of how they did business. And so, for example, when Fixed Sense was unhappy with the balance and it sought to have it adjusted in the contracts, Sunset accommodated that and met those concerns in negotiations and eventually in agreed adjustments to their contracts. And when in April 2017, they agreed on the final terms of the Heads of Agreement and the Shareholders Agreement, they took care to ensure that those contracts reflected the reality that their new deal had been in place since 1st of July. So that pattern of conscious and deliberate contractual negotiation and trying to adjust their relations in light of the success of the business is contrasted with the position taken by the Fixed Sense parties in these proceedings, where they're asking the court to disapply the contracts and invalidate the agreements that they entered into. And that's one aspect. But there's also apparent from their evidence that they're asking this court to join with them in pretending that the real commercial dealings of the parties never existed. And that includes the commercial bargain that underpinned the new the new fee structure, and indeed Fixed Sense's new equity holding. It asks you to ignore the substantial benefit obtained by Fixed Sense under those arrangements, over 3.1 million dirham and 2.5% equity, compared to 82,000 dirhams per year under the nominee agreements, which was the symbolic amount. And the fact, not in itself disputed, that Miss Herz has only ever held the nominee shares in order to satisfy the requirements of the law. She's not a partner. She never voted or is not entitled to vote except by the direction of my clients. And she never contributed or expected to contribute to the capital of the companies. Now, obviously, there's an issue on that capital contribution, but that's the sole issue of the check, which I'll come back to. So it's an extraordinary and outrageous claim, obviously coming as a nasty surprise to my clients, that Ms. Herz attempts to hermetically seal her relationship as a nominee from the Fixed Sense contractual arrangements, and to allege that those agreements do not operate as a whole. And that is completely contrary to the facts. It's contrary to the relationship of trust that they entered into in express terms under the contracts. It's contrary to her own evidence that she set aside the nominee agreements and didn't really press or expect any payment under them. And the sequence of legal attacks that has been made on the nominee agreements were described by Justice Cook as ambitious. And notwithstanding the care that was taken by Justice Cook in the immediate judgment applications and by the Court of Appeal, It's as if they haven't spoken at all when one reads the skeleton argument of my friend. It's undeterred, having put us all to the trouble of having gone through an immediate judgment application. It's as if not a word of those judgments has been taken into account by the other side. There is no tangential touch point of reality in many of the arguments being advanced by the other side. And they've been maintained with sort of metronomic repetition, despite the fact that they do not stand up and have been looked at carefully by this court already. And I think that that is a striking aspect of the other side's skeleton argument. Obviously, Justice Giles, I'm sure it's caught your eye that a public policy argument has been raised in respect of the enforceability of the nominee agreements. And on our case, that this is really a red herring. The nominee agreements themselves were not contrary to public policy, and they never were. The requested transfers would never have brought about at any time a violation of the law. And it's now obviously been put beyond doubt by the reform of the law. Now, we're obviously happy to address you in relation to that. And I think we let the court registry know this morning that my co-counsel, if needed on this, is Mr. Mossab Ali, who's Part 2 registered. And if you wish, we can address you in the course of this hearing on some of the law. You will have also seen that Mr. Khaled Gamaldeen, colleague in Al Tamimi, filed a responsive witness statement to certain legal arguments that were raised by Mr. Nazar on the other side. The status of those statements obviously is a matter for the court and how much weight you wish to attribute to them. Primarily, we will be relying on our legal submission, but obviously Mr. Gamaldeen is available, having put in a statement, he's available to give evidence today. In relation to the contractual framework, we say there's no ambiguity. The only point on ambiguity was the cross default clause itself, from which you will have seen the argument and response of Justice Cook on the immediate judgment application. We say the cross default clause, as indeed so provisionally found by Justice Cook, was a central logical feature of this commercial relationship. The heads of agreement and the shareholders agreement, nominee agreements, part of something clearly entered into by the parties in building a specific contractual tripartite relationship, and that is enforceable on our case. The agreements themselves are, I think you said you've already had a look. The shareholders agreement is at page 507. The nominee agreements are at pages 411 and 430, and the heads of agreement is at page 379. And we say, obviously, that we don't have time in this opening to bring you through them, but a reading of those agreements, it's absolutely clear what the parties intended, and that is the framework for their relationship of trust. As I say, that relationship of trust is made express in clause 5, common clause 5.1 of the nominee agreements. It's also expressly acknowledged in common clause 5.2 of the nominee agreements that no money was ever paid by Ms. Herz for the acquisition of any shares in either company. Yet that acknowledgement is entirely ignored, and indeed the relationship of trust betrayed by the position she's now taking. Are you looking at that now?
I don't have in my mind, you said clause 5.2, and I want to look at that now.
Very good, thank you. That's on page, the nominee agreements, if we look at the black tap one, it's on page 411.
Yeah, I see it.
My colleague will pick it up.
Yes. Just so that everyone knows, I have printed some hard copies of the text of the witness statements and of the vital agreements, and I'll be working off those because that is a much better
Thank you.
Things in the future. But when we get to other documents that you want to refer me to, or in the course of the evidence you're taking a witness to, I'll need to follow them through case lines.
Very good. Thank you for that clarification. And for the record, the page number is 413. Clause 5.2 reads, the nominee acknowledges that Sunset owns all the beneficial and economic interest in the nominee shares, and that the nominee has not paid any amount towards the purchase of the nominee shares. The nominee also acknowledges that Sunset is the sole and rightful owners of the nominee shares. And that acknowledgement reflects on our case the reality and contradicts the suggestion that in June 2014 she paid money for the acquisition of her 51% shareholding, registered holding. The evidence, if I can try and help, I mean, this is my own formulation, and there may be blurring borders as to how I've analysed it, but I've identified 4 rough phases of the sequence of the parties' dealings. The nominee agreements themselves were Fixed Sense's business model, and they came and right from the start they made the overtures and said, look, we provide nominee services, this is what we can do for you. So that first phase from about to the late 2013 through to November 2014 was what I call the excitement phase. And parties are clearly getting on well and building their relationship. That ends with an email on the 13th of November 2014 from Mr. Lufty, where he says, "Look, we're not happy with this. We want in for more." And then the second phase I've identified is from about the end of 2014 to April 2017, and that's when the parties knuckle down and they negotiate these new arrangements, the sort of negotiation phase. And then the third phase is from April 17, when the agreements are formally in place, up until the 1st of August 2019. And that's the new deal operational phase, where they're up and running. They're running, sorry, April 16, I should say, April 16, because it goes back to April 16. And they're running the new arrangements. But on the 1st of August 2019, Ms. Herz sends an email to Mr. Gonzalez, following Mr. Gonzalez's offer of 3 potential options for a further refinement of their relationship, because again, they weren't happy with the dividend policy in the course of 2019. There were lots of communications on this, which you'll hear about. And then on the 1st of August, Ms. Herz says, look, from now on, please deal with my lawyers on this. And so that then marks the beginning of what I call the unhappy phase, the 4th phase, where effectively from August up until termination in February 2020, there are unhappy dealings between the parties. And it's clear to my client during that phase that the practicality and benefit of the arrangement has come to an end. So the share option is a specific issue for your determination. I've already addressed you, I think, in relation to that. The EBITDA you've asked about. Our case is that the true position is that they didn't exercise the option within the commercially agreed window. And just on one point of detail on that, the agreed window under the shareholders agreement, it's expressed to be from the adoption of the accounts for the financial year in question. We've always treated it as from the communication of the accounts. So in the case of the 2018 audited financials, it was the 5th of September 2019 was the start date for that, from the purposes of the parties always treated it as the communication of it naturally. I've already mentioned that the misrepresentation case really, even at its height, it doesn't get off the ground, because it doesn't, and it's clear from the evidence of what Ms. Herz says herself, that she knew what she was doing when she entered into the nominee agreements. She had an expectation that future arrangements would be entered into. Our case is that those arrangements were the very arrangements that were in fact entered into. Unfortunately, there are the pleadings and the evidence are littered on the other side with allegations of bad faith and dishonesty. And it's quite striking. I don't know if you've had the opportunity to go through the counterclaim and the evidence in support of the counterclaim, but there are numerous allegations of bad faith and dishonesty, which, in our respectful submission, ought not to have been made, and that there's no basis for them. Coming back to the check, and I'll close with this. The purpose of the check has been explained by Mr. Gonzalez. As I say, it was brought onto the pitch late in the day, and Mr. Gonzalez's account is fully backed up and traceable in the evidence. It's a falsehood, unfortunately, and it was never raised in response to the original defence of the 024 claim, or the previous demands for transfer. And in our submission, it really is a desperate matter for the court, obviously, but it really is a desperate afterthought. We say it's overwhelmingly obvious from the contemporaneous documents that this relates to provocateur. There are invoices, there are contracts, there's a consulting contract, there are WhatsApp communications between Mr. Gonzalez and Ms. Herz, showing quite clearly what this is. Giles, Mr. Gonzalez company that operates Provocateur, is not part of the Sunset Group, and the Provocateur has no connection with Sunset Group. And I don't think Ms. Herz, on her evidence, when one looks at the portions of her evidence relating to this, she doesn't allege that Provocateur is. What she says is, this check had nothing to do with Provocateur. It had something to do with Sunset Events, which is another subsidiary of the Sunset Group, which indeed she does have some involvement in as a nominee, as you'll hear. But she also says not just for Sunset Events, also other companies which were yet to be formed as part of the Sunset Group. So it's a bit of a stretch that a check that was paid in June 2014 was towards a capital contribution to the shares of entities that had yet to be even thought of. And you'll hear evidence on that from Mr. Gonzalez. Our case is that the money actually that she paid, the 450,000 dirham, was only resting in Fixed Sense's account for a few days, as Father Ted would say. And she got a 50,000 payment for that, for a 10% payment for just simply taking the money and routing it through Fixed Sense. So we say that this check business is entirely contradicted, not just by all of that, but by the entire dealings between the parties, as you'll see in the email communications from 2015, 16, 17 through to 18, 19. All the contemporaneous documents and communications that are before you. There's not one mention of Ms. Herz having paid for shares. Indeed, the thrust of her own evidence often, and the thrust of all of the dealings between the parties in terms of how they should adjust and how Fixed Sense should get a fairer cut, are based on the fact that the sponsorship arrangements, in their view, were not fair, and that they should be cut in for more. No suggestion in any of those dealings, any communication from Ms. Herz or Mr. Lufti, that they were in fact shareholders having already paid for Black Tap shares, having already paid for Brickhoven shares, or indeed having already paid for Sunset Events shares. So it is as I say, regrettably, on our case, it is a falsehood. It's unsupported, and it's obviously a central issue for this court to determine. Those are my opening remarks.
Yes, thank you, Mr. Nominee. Mr. Iqbal, you would like to make an opening at this point also, I gather?
I'm grateful, my lord, yes. My lord has around 1,000 pages of factual evidence in this case. We say what goes to the heart of this dispute between the parties is number one, clause 5.5 of both the nominee agreements, and they require Ms. Herz to transfer her shareholding in Black Tap and Brick Oven. It is Sunset's case that Ms. Herz failed to comply with clause 5.5. As a result, the cross default clause in the heads of agreement was triggered, and Sunset was entitled to terminate heads of agreement. We would seek to persuade you that number one, clause 5.5 of the nominee agreement is unenforceable for a number of legal as well as factual reasons. The most glaring factual reason that we shall put, and we shall seek to persuade you on the basis of the evidence that you will hear, that those nominee agreements would not have been entered into by Ms. Herz except for the express misrepresentations made by Mr. Antonio Gonzalez Ortuno, and we shall demonstrate that by way of the evidence before you. As a result, we say that whether the shares in question, and this is the secondary position. The primary position is the shares in question in all of the companies were beneficially owned by Ms. Herz. The secondary position is that alternatively, even if the shares were held nominally, that doesn't help Sunset, because Sunset is after enforcing clause 5.5, which requires Ms. Herz to transfer the shareholding in question. So unless clause 5.5 is upheld, whether the shares are beneficially owned or nominally owned, that is besides the point. Sunset must persuade you that clause 5.5 is enforceable. At the same time, they must persuade you.
No, I think it might be the reverse. You must persuade me that it's not. Prima facie, it is, isn't it?
We would seek to persuade you it is not. So it is at this point that the parties are at heads-on dispute with each other, both in law and in fact. Having said this, that this is what goes to the heart of this case, by way of background, we would seek to submit that it was since 2013 when both parties had started developing business arrangements of various kind with each other, and in those number of years they had developed a degree of trust and confidence on each other. They were business successes, they were demonstrable trusts, and they wanted to take their business relations to another level. As a result of that mutual understanding, both parties in 2016 came up with the idea to bring a number of arrangements, a number of different agreements under one umbrella, and that was the heads of agreement. Under that heads of agreement, Sunset were to pay two kinds of fees. One was the fixed fee. The second was the anticipated profits, which was share in the business's profits. And Mr. Antonio Gonzalez Ortuno calls that as advance dividend. By that, we would seek to demonstrate that it shows that not only Ms. Herz was entitled to fixed fee services for her consulting services, she also had a part in the profits, shares / dividends of the business. Hence, she was the beneficial owner. We would also seek to demonstrate in the course of evidence that at least there were 8 different contracts between these parties, and Mr. Antonio Gonzalez Orchuno, who I shall from now on refer to as Mr. Orchuno, we would demonstrate that Mr. Orchuno would say in regards to each of those 8 agreements that they do not reflect the reality, and the reality is different. We would also seek to show through a number of documentary evidence that again Mr. Orchuno is seeking to mislead the court by giving a different explanation for those documentary evidence. He is giving a different color to those documents so that he can defeat Miss Al-Herz's claim that she made the payment of 450,000 dirham as part of her capital contribution. We dispute 3.1 million dirhams payment as suggested by my learned friend. We also would seek to submit that the recent change in CCL in the UAE is irrelevant to this dispute. When it would come to the closing submissions, I would seek to submit that the judgments of Justice Sir Jeremy Cook and the Court of Appeal do not at all assist Sunset. We would also seek to submit that the Heads of Agreement and the Shareholders Agreement were not entered into in April 2017, as my learned friend suggests. I am not going to take long in my opening submission and would simply submit that based on the evidence that you would hear, we would seek to submit that clause 5.5 was not enforceable. As a result, the cross-default clause could not be triggered, heads of agreement could not be lawfully terminated, plus the fact that Sunset did not deliberately provide the financial accounts to Ms. Al-Herz and Fix Sense so that they could lawfully exercise their option rights in terms of the 2.5% options shares in the holdings. I am deliberately seeking to observe brevity in opening because I have one ancillary matter before we start hearing the evidence. With your leave, if I might address your lordship on that ancillary matter, because I am under strict instructions by my client to pursue that.
Have you completed your opening?
My lord, yes, I have completed my opening.
Well, the openings have demonstrated to me that the extent to which I think I'm going to need the help of counsel in closings to really get to grips with what he says the facts were. I mention that now because the agreed agenda allows 20 minutes or thereabouts each. It seems to me quite plain that that is not going to be enough. So we will obviously have to keep tabs on timing depending how the evidence goes. But bear in mind that I am going to be asking for your assistance. And if that means that we need to go beyond the 2 days which are allowed for this case, we will have to do so. All right, now you have an application to make, Mr. Iqbal.
My lord, yes, in fact, an application has already been made by those instructing me seeking summons against Mrs. Liz Riachi, who is the wife of Mr. Orchuno. The application was made because it is Mr. Ortuno's case that the payment of 450,000 dirham made to Mrs. Riachi in June 2014 by Ms. Hana Herz was reflective of the capital contribution into the business arrangements of the parties. That was reflective of a contribution into the companies that were then existing, plus the companies that were to be formed in reasonable future, in foreseeable future. For those reasons, an application was made by those instructing me, just recalling on top of my head, maybe around 2 weeks in retrospect from today. It was in relation to this application that Mr. Ortuno then filed his 4th witness statement, followed by his 5th witness statement, and we see obviously resisting that application. It is my understanding, and also of those who are instructing me, that the registry has not yet made, well, a decision has not yet been made on the applications for summons against Mrs. Riachi. As I submitted earlier on, that I am under strict instructions to pursue this application. It is for this reason that I seek to put it before this court. Now, I perfectly understand myself that if this application is to be granted today, I do not see in any way, shape, or form this trial going ahead today. It will have to be put for another day. Having observed brevity and said this much, I pursue the application before your lordship.
Justice Giles. Yes, Justice Giles, there is no application before the court.
I was saying I know nothing about this application, and before we go any further, I would want to see the documentary evidence of the application being made.
There is no application, never was made, and that's in contravention of Part 30 of the rules, obviously. It's not an application that can be done on the hoof. It requires service of the person being summoned 7 days before the hearing. No such service has taken place. No application has been made. It is what did happen was that in a witness statement filed, which we describe as the 5th witness statement of Ms. Herz, filed on the 16th of February, reference is made to her wish to summons Ms. Riachi. But that was it. That's all that has ever happened. So Mr. Iqbal is under a misapprehension as to what those instructing on his side have actually done. They have not made an application.
First of all,
wait a minute. I think you need to take some instructions, which you can do when we next break. But we might have a short break in an hour or so. You can take some instructions and tell me what really has happened on your instructions. But I need to know what happened. If what Mr. Dillon alone has said happened, I think it's fairly obvious that there are significant problems quite apart from the position, even if there was an application. So I'm going to defer this. You can take instructions when we next have a break. I will leave it to you to raise it again. If you do not raise it again, I will assume the matter is dead. All right?
That sounds pragmatic to me, my lord. Thank you.
Okay. All right. So our first witness then is Mr. Ortuno. Now, what is the correct mode of address, Mr. Domino?
I think it's Mr. Gonzalez. You know, with Spanish names, there are usually one that is commonly used, and in Mr. Gonzalez's case, it's Mr. Gonzalez.
All right. And while I'm on that subject, what's the best mode of address of your client, Mr. Iqbal? How do I address her? Is it Miss Herz or what?
Mrs. Herz.
Mrs. Herz. All right. Thank you. All right. Well, Mr. Dillon Malone, you'll call Mr. Gonzalez.
Yes, indeed. He's just taking his place in the adjoining room. No disrespect was meant to Mrs. Herz in my reference to her as Miss Herz. I'll just wait for him to appear on the screen, Justice Giles, if I may.
I should say that I expect the witnesses to all adopt their witness statements on oath.
Yes, indeed. Justice Giles, may I ask, do you wish me to do that in sequence for each one, or can I do it as a batch?
Well, as each one is called, they need to adopt their witness statements, do they not?
Yes, but I can do it by reference to the 5 witness statements filed.
Oh, I see. Well, no, I think we do have conflicts of fact here, quite significant ones, and I think we need to be very careful that each witness must very carefully swear to the truth of each witness statement serially.
Thank you. Okay. Oh, I'm told that there's 2 minutes. Justice Giles, would you like to rise for 5 minutes? Just we're having a technical difficulty. I'm told it'll be fixed in 2 minutes.
Well, why don't we all sit here looking at each other for 2 minutes?
Very good.
My lord, availing these 2 minutes, might I be allowed to rise to fetch a glass of water?
Of course.
Certainly, thank you.
Indeed, I will do the same.
Okay, thank you. I've got the volume. I'm told he's in the waiting room, so perhaps the registry might please allow him in. Is the registry?
Yes, I have allowed him in.
Oh, thank you very much. No, I can't see him yet. Can anybody see him?
No, I don't have him yet.
He might have disconnected. Please ask him to join again.
I'm terribly sorry, Justice Giles and Mr. Iqbal. I'll just have a look myself and see if I can assist.
We had him during your opening when we shouldn't have, and now we can't get him.
There he is. Thank you, Mr. Gonzalez.
Pleasure.
Yes, Mr. Gonzalez, can you see and hear me?
Yes, I do.
Thank you. Mr. Iqbal, can you see and hear Mr. Gonzalez?
Pardon
I
me,
do,
sir.
my lord, yes. Thank you.
Right. Shana, would you please swear Mr. Gonzalez?
Yes, Your Honor. Would you please state your full name and occupation for the record?
Antonio Gonzalez. I am the CEO of Sunset Hospitality Group.
Would you please confirm if you would like to affirm or swear today?
I confirm to swear or whatever you think is appropriate.
Okay. What will you be swearing on today? Do you have the Holy Book in front of you?
I don't think we do, so I think we will have to go for the other option.
Okay. So please repeat after me.
After.
I solemnly declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
I solemnly affirm, I declare that the evidence I will give the truth, nothing but the truth.
Will be the truth, the whole truth, and nothing but the truth.
The truth, the whole truth, and nothing but the truth.
Thank you, Mr. Gonzalez. Yes, Mr. Nominee.
Thank you, Mr. Gonzalez. Mr. Gonzalez, you have sworn a total of 5 witness statements in these consolidated proceedings. Isn't that right?
Yes.
Yes. And I'm going to ask you, please, in sequence, to affirm and confirm on oath the truth of each of these witness statements one by one. So the first one is dated the 10th of March 2020, and it's on page 337 to 343 of the bundle.
Mm-hmm. Yes.
Thank you. And can you please take a look at your signature at the conclusion of that witness statement, page 343, I believe. And can you please confirm that that is your signature and that you swear to the truth of the matters contained in that witness statement?
Yes, totally, I confirm.
Now, the second witness statement you swore was on the 5th of May 2020. It's at page 559 of the bundle to page 564. And again, can I ask you to please look at the signature on page 564 and confirm that the matters contained in your witness statement are the truth?
Yes, I confirm.
Thank you. And then you swore a third witness statement on the 15th of March 2021, and that's at page 1093 to 1104 of the hearing bundle. And if I could ask you again, please, to look at your signature on page 1104 and confirm that this is your signature and the truth of the matters contained in that witness statement.
Yes, I confirm.
Now, your fourth witness statement was sworn more recently on the 22nd of February 2022. It's at page 1718, 1718 to 1721. Can I ask you to look at your signature on page 1721 and confirm that is your signature and the truth of the matter set out in that statement?
Yes, I confirm.
And finally, your fifth witness statement was just sworn on Friday, the 25th of February 2022. It's at page 1888 to 1889, and your signature appears on page 1889. Can you please confirm for the court that that is your signature and the truth of the matters set out in your statement?
Yes, I confirm.
Thank you, Mr. Gonzalez. I believe, do you have any matters that you wish to clarify in any of your statements?
From my side, I think it's all self-explanatory.
Yes. Now, please, can I ask you to answer the questions of Mr. Isbal and any questions of Justice Giles?
Of course.
Thank you, Mr. Iqbal.
Thank you. Mr. Gonzalez, I'm referring to your second witness statement of 5th of May, 2020. My lord, in the bundle, it can be seen at page 559. Once you have it in front of you, Mr. Gonzalez, please tell me.
I have it in front of me.
Thank you very much. If you can please go to paragraph 5.
Mhm.
Can you see where it says, I do not disagree with the statements made by the defendant at paragraphs 5 to 9 of a statement? Can you see that?
Yes.
Okay. Now, it's fair that I must show you what is that statement of the defendant. To do that, can I please trouble you to refer to page number 457 of the bundle, please? And bearing in mind, we shall revert back to this paragraph 5 after we have seen that statement of Mrs. Herz. Okay? And once you have Mrs. Herz's statement at page 457 in front of you, please tell me.
I do.
Thank you. Let's go to paragraph number 5 at page 458, please.
Yes.
If you can please kindly have a bird's eye view of paragraphs 5 to 9, please, and confirm that you have read them.
Okay.
So it appears to me you have read those paragraphs and you...
Not yet.
Okay, take your time, please.
Paragraph, which one? From
Paragraphs 5 to 9.
okay, I read all of them.
I'm very grateful. Thank you. Now, let's revert back to your witness statement at page number 560.
Yes.
And now we are back to paragraph 5 of your statement. Am I correct in my understanding that you say that since 2013, you have had number of business agreements with Mrs. Herz and Fix Sense, and in all of those business agreements, Mrs. Herz was a nominee shareholder. Is that correct?
Yeah.
Thank you very much. From this point on, I am taking you. Okay. I'm now taking you to your fourth witness statement. That is at page 1718, dated 22nd of February, 2022.
Yes.
This statement has a number of exhibits. Can I please trouble you to go to page number 1795, please?
One 1795.
That is correct, please.
Okay. Yes.
Can you confirm if you can see that on the top right-hand corner, it says share selling agreement and supplement of MOA?
Yes, I can see that.
And underneath, you can see the first name is Mrs. Hana Habib Mansoor Habib Herz, and number 3 is your name. Can you see those?
Yeah, I can see that.
Let's move on to the next page, 1796, please.
Yeah.
Towards the end of this page, bottom left-hand corner, you can see the heading Preamble.
Yes.
And we can see that this memorandum is in relation to Sunset Events Management LLC, dated 11th of March, 2014. Can you confirm
Yes.
that?
Yes.
Thank you. Now, if we then go to page number 1799, please.
Yes.
In the middle of the page, we can see a table that gives distribution of shares. It says first party, and we have already seen is Mrs. Herz, had 51% shareholding, and then it's your name, third party, you were holding 9.6% shareholding. Can you see that?
Yes.
Just for a moment, have a look at page 1802, please.
Mm-hmm.
1802, you can see that there are a number of signatures, and if you look at third party, there's no name mentioned, but do you confirm that these are your signatures?
There is one signature there that is mine, yeah, on the Arabic side.
Thank you very much. And also, if we also move on to pages, sorry, just page 1818, please.
Mm-hmm. Yes.
This is professional license for Sunset Events Management. Can you see that?
Yes.
And you can see that this license was issued on 30th of March 2014. Can you see that?
Yes.
And towards the bottom left-hand corner of this page, it shows print date 15th of March 2018. Can you see that?
Yes.
And let's go to the next page, 1819, please.
Yes.
And here you can see that Mrs. Herz owns 51% shareholding in Sunset Event Management. And this is by the print date of 15th of March 2018. Can you see that?
Yes.
Now, what you can also see is just underneath Mrs. Herz's name, Sunset Hospitality Holdings holds 46% shares. Can you see that?
Yes.
Is this correct that by March 2018, Sunset Hospitality Holdings Limited's shareholding had increased to 46% because the other parties, other partners, had previously sold their shareholdings or transferred their shareholdings to Sunset Hospitality?
Yeah, this was a consolidation of the different partners under Sunset, and Hana remained as a local sponsor.
Thank you very much. Can I trouble you to please revert back to page number 1799, please?
Yeah.
Once you're at 1799,
Yeah,
please.
I am.
Thank you. Again, we're back to the same chart. First party, Hana Herz. So from start, she was 51% shareholder. But it is your case that this document, which shows Mrs. Hana Herz as the actual shareholder in 51%, was not in fact the real actual shareholder. She was only a nominee. Is that your understanding, isn't it?
No, it's not my understanding. That's the fact. That's the truth.
Fine. So if this is the truth, do you agree with me that this page, this particular table, does not reflect the reality, what you believe is the reality? Do you agree with me?
That table reflects the framework of the regulation where a local Emirati person has to hold 51% of the shares.
Yes.
But as also is a fact, Sunset Event Management, when it was set up, Ms. Hana gave us a full power of attorney, a document that is a full power of attorney to my name, to represent and deal with all her shares, beneficial, shell, purchase, and so on. And that was dealt with long ago with respect to that company.
Mr. Gonzalez, my question was absolutely straightforward, and I repeat that for you. Is it your understanding that this table on 1799, insofar as it relates to Mrs. Herz's 51% shareholding, does not tell the truth? Yes or no?
Again, I'm not an expert in law. I'm not the right person to say that. This table
I'm sorry,
reflects as my understanding, or you ask me a question, I'm trying to answer.
Well, it's not a
as my
legal
understanding goes, this reflects the customary framework where a local sponsor is required to hold 51%. So on that sense, yes, she's reflecting 51%. On the beneficial, she was purely representing the rest of the other parties.
Would it be fair to say that this shareholding of Mrs. Herz does not reflect a complete picture, to say the least?
I guess
yes or no? Yes, okay, thank you. The next document that I wish to show you is what we all are calling as heads of agreement. Can I trouble you to please go to page number 379, 379, please.
Yes.
When you have it in front of you, please tell me.
I do have information.
Brilliant. Thank you very much. You recognize this document and you have seen it before, have you not?
Yes.
Let's turn to page number 380, please. 380.
Yes.
Just below middle of the page, you can see effective date, and it reads as the effective date of this agreement shall be 1st July 2016, and it shall remain in force for an unlimited period. Can you see that?
Yes.
Thank you. One second, please. Also, if you can turn to page number 383, please.
Yes.
Here you can see just above this signature table, we confirm our agreement to the terms set out above on 1st of July 2016. You can see that, don't you?
Yes.
And then underneath are your signatures, Antonio, Gonzalez, or Chino. You can see that, right?
Yes.
However, as I understand, it is your case that this agreement was not signed on 1st of July 2016. Is that correct?
It was signed later and backdated.
So the answer is yes, isn't it?
Yes.
Thank you. So would it be fair to say that in your view, insofar as this date of 1st of July 2016 is concerned, this document does not reflect the true picture? Do you agree with me?
No.
Why not?
The agreement and commercials that were related to the document were effective from the day that, from the 1st of July. So payments were in place according to the agreement and based on the spirit of the agreement, regardless of the date that it was signed. There were some delays on signature process, but then both parties, ourselves and Fixed Sense and Hana, recognized that the agreement was being effective from that day because the payments were done according to the agreement dated from the 1st of July.
I put my question in a slightly different way. Page 383, just have a look at that, please.
Yes, is this one? Okay, yes.
Will you agree with me that page 383 shows as if you had signed this document on 1st of July 2016? Doesn't it?
I cannot judge that. I cannot comment on that.
Well, why you can't comment on it? It's obvious. You can see that your signatures and the date above is 1st of July 2016. So I suggest that this document reflects as if it was signed on 1st of July 2016.
As if it was.
Wait to my question, please.
Sure.
I suggest this document reflects as if it was signed on 1st of July 2016. Do you have any reason to disagree with me?
No.
Thank you. But it was not signed on 1st of July 2016. That is what you said in your witness statements.
No, it was signed later. It was signed later, yes.
Right, okay.
But it was effective from the 1st of July, from a commercial and practical matter.
Yes, that effective date is a separate matter. I'll come to that. So please, at the moment, stick to the question that I'm asking. Okay, fine. Let's move on. I am now showing you another agreement that is called the Shareholders Agreement, and you can see that at page 506, please.
Yes.
On page 506, just above the page, you can see dated 2016, but there is no date on that. Can you see that?
Yes.
But if you go to page 508, please, top of the page.
Yes.
This agreement is dated 1st of July 2016. You can see that, right?
Yes.
If you then turn to page number 522, please.
Yes.
We can see your name underneath Sunset Hospitality Groups Limited and your signatures. You confirm that these are your signatures, correct?
Confirm. Yes.
Brilliant. Let's come back to page 508, please, then.
Yes.
And here, you confirm that this shareholder agreement was indeed and in fact signed on 1st of July 2016. Do you accept that?
I don't remember. My recall is that it was signed later and backdated. I'm not
You
sure.
understand that anywhere in any of your 5 witness statements, any reason why you didn't mention that, as per your understanding, shareholders agreement was not signed on 1st of July 2016?
No, I don't think it's relevant. It was executed in, again, from a commercial and practical matter from those dates, because payments were done according to that and all the commercial arrangements were done around that agreement. But I'm not sure about it. I think it was signed much later and then backdated to this date.
Right. So will you then agree with me that insofar as the date of 1st of July 2016 is concerned, this shareholders agreement does not reflect the reality, does it?
Well, it does reflect the reality that it was executed from that day from a commercial and practical matter. And the spirit of it was from the 1st of July of 2016.
Okay,
The actual date when the signatures were done might differ from that.
okay. So once again, I come back to a similar question I asked previously. Will you agree with me that this document suggests as if you had signed it on 1st of July 2016?
Yes.
But you say that in fact it was signed sometimes later, correct?
Yes, correct.
And therefore, this date on 1st of July 2016, which shows it was signed on this date, does not reflect reality, correct?
The date there is not the date where the signatures were done, but once again, I want to reiterate that it was effectively executed from that day from a commercial and practical matters.
Are you being purposely evasive to my very straightforward question?
Mr. No. I will not have that sort of cross-examination, please.
Absolutely, my lord. I would withdraw that and move on. Moving on, let's go to your second witness statement at page 561, please.
Sorry, can you repeat the page?
Absolutely. It's 561, please.
561. There's some sound problem. Yes.
Paragraph 16.
16.
Toward the end of the page.
Yes.
I'll do it afterwards.
The defendant is therefore quite wrong to say that the heads of agreement and / or the shareholders agreement were entered into in July 2016, and I disagree entirely with that, with what the defendant says at paragraph 15 of her witness statement.
Now, I can just please ask, sorry to interrupt, Mr. Iqbal. I wonder, could you please refer the witness to paragraphs 14 and 15 directly above? That's because it's linked to that.
That's a fair point, absolutely, yes. Can you please read for yourself paragraphs 14 and 15 of this statement, please?
Yeah, exactly. As you can see here, it's
You have
as
to
per
wait for my
Marwan.
question. Yeah, you have to wait
Sorry,
for my
yeah.
question. Yeah?
Yeah, sure.
Okay. So Mrs. Herz says that heads of agreement and shareholders agreement were signed on 1st of July 2016. You say that is incorrect. You tell us the date when these two agreements were signed, please.
I'm not sure the exact date that this was signed. I will need to go back and see exactly when is what that date is. But as you can see here, from the 1st of July is when we switched to a 61,000 fees and replenished to all the fees, and that's when it became practically in place.
Is there any documentary evidence to show us when these two agreements were in fact signed? Can you show us any piece of paper?
I'm not aware.
Thank you very much. I'm moving on. This time, if I can please ask you to go to page number 385, please.
Yep.
Can you confirm, if you look at top left-hand corner, that this is Memorandum of Association for Black Tap?
Yes.
You can see Mrs. Herz as the first party and Sunset Hospitality Holdings Limited as the second party.
Yes.
Bottom right-hand corner, there is a stamp which shows as if this document was either executed or came into force on 26th of June 2016. Is that correct?
Yes. Yes.
Let's go to page number 390, please. 390, please.
Yes.
And you can see just in the middle of the page, just below paragraph 6.2, first party, Mrs. Herz, holds 51% shareholding, and the second party, Sunset Holdings Limited, holds 49%. Can you see that?
Yes, I can see.
And if we go to page number 410, please, 410.
Yes.
You can see middle of the page, second party, your name is mentioned, and these are your signatures. Can you see them?
Yes.
Let's come back to page number 390, please, 390.
Yes.
And again, back to the shareholding structure. Will you agree with me that this shareholding structure does not reflect Mrs. Herz as 51% nominee shareholder?
I'm not sure I understand the question.
Okay,
See,
absolutely fine. I understand. I put it differently. This share structure shows Mrs. Herz as 51% shareholder, but you say this is not true because she was a nominee. Am
exactly.
I right?
Correct.
So, to that extent, as you say, this share structure does not reflect reality, correct?
It reflects, again, same as the case that you mentioned before. This reflects the, I think, the customary structure of LLCs in UAE or in Dubai, where the local sponsor has to have 51% on these kind of documents. But from a beneficiary perspective, from a true ownership perspective, Hana was purely a nominee representative, and the second party, in this case us, Sunset, was owning 100%.
So to summarize it, insofar as you as a person is concerned, this document does not reflect the reality, and it is against your understanding, correct?
I cannot judge if it reflects reality. That's as you know here, it's not black and white when we are talking about. It reflects the reality of the local sponsorship, but it doesn't reflect the reality of the true ownership. And I think that's we made it clear before.
Okay, just 1 second, please. I am now moving on. If I can please refer you to page number 412, please.
Yes.
And you can see that this is the, well, in fact, yes, this is the nominee agreement for Black Tab. That's your understanding too, correct?
Yes.
And here you can see second party is Mrs. Herz, third party Sunset Hospitality. You see that?
Yes.
On page number 416, on the top of the page, we can see signature. No name is mentioned, but you confirm that these are your signatures, right?
Yes, it is.
Thank you. And let's come back to page number 413, 413, please.
Yes.
Here we can see clause number 3, consideration, and 3.1. If you can please take a moment to read that for yourself.
Yes, I can read. Yes.
First of all, you agree with me that this was a symbolic price and you had no intention to pay that to Mrs. Herz. Is that correct?
Both parties, we agreed that this was a symbolic, and this payment was part of the head of terms remuneration and shouldn't be included here as a factual payment.
So you had no intention to pay this sum to Mrs. Herz. Is this correct?
Both Hana Herz and Fixens and us never had intention to have this payment done.
Right. Then why was this mentioned here in clause 3.1? What was the purpose when parties had no intention to abide by it?
I'm not sure of the legal background of that, but I remember that there has to be an amount, even if it was 1 dirham. There was like a legal requirement to have that amount. Again, I'm not expert on that, but that's the lawyers can clarify further.
Let's go to page 414, please. The next page.
Yes.
Clause 5.5. Please take a moment to read that.
5.5. Yeah. Yes.
Okay. So, in relation to 5.5, it is your case that regardless of your intention about paragraph 3.1, both parties intended to abide by 5.5, correct?
Yeah, of course.
So what you are telling us is that we should ignore clause 3.1, but we should accept clause 5.5. Is that correct?
No, I don't think we should ignore any clause here. What I'm saying is the compensation of Hana and Fixens for the local sponsored service was commercially covered under the head of terms.
That's a different point, and I will come to that in a moment. What you're saying is that clause 3.1 should not be taken at its face value, but clause 5.5 should be taken at its face value, correct?
I'm not sure I understand the question.
Right, fine. What you say is clause 3.1 does not show the true intention of the parties, but clause 5.5 does show the true intention of the parties. Is that correct?
Again, I want to repeat this because it might lead to misunderstanding. The clause of the payment was included on a broader commercial agreement where we were paying a much higher amount for Hana to be the sponsor for this company and other entities and provide some other services. So her compensation was addressed on a broader agreement, which is the head of terms. I don't know. I mean, like that's as far as I can go. I want to.
My lord, my view, I haven't got the answer, but I heard your lordship's earlier observation. Unless your lordship can be assisted on this point, I wish to move on. If it can assist your lordship, I will persist on this question.
It's up to you to persist. What I objected to was the way you were persisting before. Do not persist in that way.
Okay.
If you want to keep on asking questions, do so. Remember that there is the law of diminishing returns.
I appreciate and I respect that. Thank you. At the moment, I'm not talking about the broader commercial agreement. I am very specific about intention of your intention, and Mrs. Elherz's intention. You want us to believe that both parties did not intend to abide by paragraph 3.1, but both parties intended to abide by clause 5.5. Is that correct?
That's correct.
Okay. So insofar as 3.1 is concerned, it does not reflect the reality, correct?
It reflects part of the reality because there was a compensation, but the compensation was much bigger than this one.
Okay, so at least not the complete reality, correct?
Yes.
Thank you very much. I now move on, and this time, if I can please refer you to page 417, 417.
Yes.
You can see top left-hand corner. This is Memorandum of Association for Brick Oven. Miss Elherz is the first party, and Piatura second party. Can you see that?
Yes.
Just towards the end of the page, next to Article 1 definition, there is a box. It's a stamp, in fact, and
Yes.
it shows the date of 3rd of July 2017. Can you see that?
Yes.
Page 419, please. 419.
Yes.
Just below middle of the page, you can see a table with shareholding structure. First party, Mrs. Herz, hold 51% shares, and second party, Piatura, held 49% shares. You can see that, can you?
Yes.
Thank you. And just moving on to page number 421, please.
Yeah.
And top left-hand corner, you can see your name. And it is put that you are managing director of Piatura, correct?
Yes. Correct.
Page number 428, please.
Yes.
The last name appears to be yours, and these are your signatures. You confirm that, don't you?
Yes. Correct.
Thank you. So, this memorandum of association, let's come back just for a moment to 417, please.
Yes.
And you can see that it came into effect on 3rd of July 2017. You agree with me on that, don't you?
Yes.
Thank you. And if we go to 419, will you also agree with me that on 3rd of July onwards, Mrs. Herz held 51% shareholding in Piatura?
Yeah.
Agree?
As a nominee, as a local sponsor.
Now, you have just said the word as a nominee. Does it mean that this particular shareholding structure does not reflect the complete picture?
Yeah. It's the same case as we discussed for Blacktown. I refer to my previous statement.
Absolutely. I understand. Thank you. One second. I'm now moving on. It's 430, please. 430.
Yes.
This is brick oven nominee agreement.
Yes.
Top right-hand corner, you can see the date, 25th of May, 2017.
Yes.
You can see that? Okay. And then, again, we can see brick oven is the first party, Mrs. Herz is the second, and Piatura is the third party, right?
Yes.
432, please. And you can see it's clause 3 consideration, and 3.1 is identical to clause 3.1 of Black Tab. The only difference is consideration. Here it's 72,000 dirham. Can you see that?
I can see it.
So, and you also confirm that like Black Tap nominee agreement, here too, it was not your intention to pay this consideration to Mrs. Herz, correct?
This was included also in the head of terms. And if I may elaborate on why the amount is different, Your Honor.
Yeah, I will come to that. Just at the moment, it's a specific question here.
Yeah, it's the same case as the previous.
Thank you. So that's I've got my answer. Now you wanted to give some explanation. Please go ahead. I have no objections.
During that period, from one nominee agreement to the other, Hana, Omar one or both, I don't remember, but definitely the fixed sense partners expressed that it was, I don't know the exact words, but somehow embarrassing that somebody could see an agreement where there will be local sponsors and only compensated 10,000 dirhams. and they said, we understand that we are being compensated under the head of terms agreement, but we should put an amount that is bigger in case somebody sees this agreement that they feel that we are not just at 10,000 local sponsors. And therefore that amount was changed here. But the spirit was the same as the other one, and it was all compensated under the head of terms.
And I will agree with you to the extent that I have seen some emails suggesting that, and I will show you them in due course. But for a moment, let's...
Just to Iqbal, I'm sorry, it is difficult when we have it by video. You are here to ask questions. You are not here to express agreement or disagreement or add comments. Please don't.
Absolutely, my lord. I will bear in mind.
Not
Thank you.
Mr. Dillon Malone to do the same thing either.
Absolutely. I bear in mind. Thank you. So we are at the moment on 432. Let's go to 433, please.
Yes.
Clause 5.5, please.
Yes.
And this is the same clause 5.5, identical as to black tap nominee agreement, correct?
Yes, correct.
And you say that it was intention of both parties, that is Mrs. Herz, Piatura, and Sunset Hospitality, that this clause would be abided by both parties, correct?
Yes, of course.
Right. I'm now moving on, but just 1 second. Let me have a look at one of my pages, please, first. Right, okay. Before I move away from this topic, because we have 5.5 in front of us, this agreement was signed on 25th of May 2017, and clause 5 is asking Mrs. Herz to transfer, sell, or mortgage her shares to any person specified by Piatura. Let's say if on 26th of May 2017, Piatura had asked Mrs. Herz to transfer those 51% shares, she could not transfer those shares on 26th of May 2017. Is that correct?
I don't understand the question, sorry.
I'll put it a different way. As we have seen from the Memorandum of Association for Brick Oven, let's have a look at page 417, please, again.
417. You're referring that the nominee agreement is dated before the MOA?
That's correct. Yes.
Yes.
What I'm putting to you is that the agreement, which was on 25th of May,
yeah,
at that time, Mrs. Herz did not even own the shares to which she agreed to transfer. Is that what you're telling us?
Yeah, I just want to clarify something. In the nominee agreement doesn't doesn't say that she's transferring the shares. It says she undertakes to transfer the share at our request. At that time, I think the companies were under formation, and in fact, the trading of that company, I think, started in December 2017. So, yes, I don't know the order of when the agreement was done, but it's all the same.
So, will you agree with me that on 25th of May 2017, when the nominee agreement for Brick Oven was signed, she could not transfer the shares in Brick Oven because she did not hold the shares in Brick Oven on 25th of May 2017. Do you agree with me?
We didn't ask her to transfer shares at that time.
Of course, it is a hypothetical question.
Yeah.
Certainly, okay. And the Brick Oven agreement does not say that this share agreement is in relation to the shares that she will hold in future. Is that your understanding too?
My understanding is that all agreements are linked and connected and were practically and commercially executed as a whole. If the memorandum of association was delayed a few weeks from May to July, and the trading actually started in December, I find it's totally irrelevant to discuss dates because commercially and from a practical matter, everything was according to the agreements.
Ms. Herz says that after 25th of May 2017, on 3rd of July 2017, this memorandum of association for Brick Oven superseded the Brick Oven nominee agreement. Do you agree with that?
Absolutely not.
If it had not, then you could have said, or you could have amended the date on the Brick Oven nominee agreement. Could you not?
I'm sorry, Mr. Dillon, you're making an addition.
Yeah, that case has actually never been made. That there was some superseding. I just mentioned it. I'm happy for the question to be answered, but I'd just like to point out the question was put on the basis that it was Ms. Hertz's case that one agreement superseded the other. As far as I'm aware, that has never been made. That argument.
Could I say that, frankly, I'm more interested in who might have said what to who about things, not someone's impression or understanding afterwards. The cross-examination so far has not really been terribly helpful in that respect. If you want to make a case, Mr. Iqbal, that there was supersession, then you need to put to Mr. Gonzalez that something was said between them amounting to an agreement that the memorandum of association would supersede the nominee agreement, and see if he agrees or not.
Absolutely.
If you're not in a position to do that, then it's not easy to give much force to your proposition.
I agree. I was intending to put this a few minutes later, but I do this right now. Mrs. Herz says that you expressly told her that these nominee agreements for Black Tap and Brick Oven were only to show to international investors to attract their investment, and you had no intention to execute these nominee agreements against Mrs. Herz. Is that what you told her?
Not exactly. Not exactly. I think you are taking some elements of that conversation and getting out of the right contents and missing information. In each one of these companies, Sunset also had other partners that were participating on these investments and on the companies. And while myself and some of my partners have been living in Dubai for now more than 15 years, and we understand the local dynamics of having local sponsors and the 51% nominee ownership. Some of our partners that were living abroad didn't understand the dynamics, and they asked for reassurance that the local sponsor will be under specific nominee agreements limiting their interaction with the realities of the companies. We were very clear that the head of terms define all of those commercial relationship, and there will be local sponsor, and that that defines the relationship we have with Fixens and with Hana. But it was also important for good governance and for good clarity with not only with ourselves but also with our international partners that these nominee agreements will be in place. So that's the reality of the whole conversation, the background, and the explanation for those.
Can I refer you to page number 539, please?
Yes. Yes.
And you can see here, it's your email dated 10th of February 2016 to Mrs. Herz.
Yes.
And here you are referring to, it's the third line for Black Tab. We will have master franchise rights for Middle East within brackets GCC plus Jordan plus Lebanon plus Egypt plus Iraq plus Iran. Can you see that?
Yes.
And if you come to page number 523 now, please.
Yeah.
And this is your email of 18th of December 2016, and it's the nominee agreement attached for Black Tab. Is that your understanding?
That this is my email? Yes, this is my email.
Okay. And in the email, if I draw your attention to second paragraph, as agreed yesterday, we have changed the sponsorship amount to 10,000 dirhams. However, also as agreed, we acknowledge that this is symbolic. Can you see that?
Yes.
If I can now ask you to please come to page number 499, please.
Yeah.
This is an email from your lawyer to yourself dated 23rd of May 2016.
Mm-hmm.
Can you see that?
Yeah.
And this email is in relation to Black Tab nominee agreement. Do you confirm that?
Yes.
And it's the second bullet point. We are aware the agreement may not be enforceable for public policy reasons, but under DIFC law, there is less chance of such a public policy argument being permitted because DIFC courts will lie.
It got frozen.
Do something.
Mr. Iqbal, sorry, the line got frozen. I couldn't hear you.
Okay, my apologies. I was simply reading the second bullet point on this email. Can you see that? And I will not.
Yeah, I can see that. Yeah.
Thank you. Thank you. So, and if we come back to page number 498, please.
Apologies, 1 second, Mr. Iqbal, because now, since this is brought here, you can see the amount below was 100 dirham, I think, and the fee, and I moved to 10,000. That was, I think, was the referral of the change.
Thank you for drawing my attention to that. Let's come to page 498, please.
Yeah.
And is it correct that this email, which you received from your lawyers, you had forwarded that to Hana, Mrs. Herz?
Yeah.
And you forwarded that email to Mrs. Herz to reassure her that the nominee agreement might be unenforceable. Did you?
No. What do you mean it's unenforceable?
Well, the lawyer said that these nominee agreements might not be enforceable for public policy reasons. And that's what you wanted to tell to Hana, that look, Mrs. Herz, look, Hana, even if you sign these nominee agreements, it would not matter because they would not be enforced. So you will not be harmed.
Police, that's absolutely incorrect. That's absolutely incorrect and false. What we're saying here, you can read here, it's important to use the IFC in these types of agreements. But the other things I think you're speculating.
Mrs. Herz says that because you made these representations to her, that you will never, wait for me, please, wait for me. Mrs. Herz says that you made these representations to her that you will never use these nominee agreements against her. That is why on 25th of May 2017, she signed the agreement at a point when she did not even hold the shares in Brick Oven.
Okay.
That's how she signed it. Isn't this the truth?
No, of course it's not the truth. First of all, I did not do that representation that those nominees agreement will never be enforced. You are taking a comment from our lawyer to myself where they are expressing a legal opinion and not actually a certainty, but just an opinion. It's a may. And I didn't in my email or in my comments say that those agreements will not be enforced. Actually, they were enforced indeed. So that's representation. It was never there in the sense that I never implied or misled in any way that that those nominee agreements were actually in place.
If you go to page number 496, please.
Yeah.
This is your email of 10th of July 2016.
Yeah.
And this email is addressed to Marwan, who is Mrs. Herz's husband, correct?
Yes.
And if you look into the second last paragraph, as for the nominee agreement, it was sent a while back to Hana and cleared by your lawyers. I will forward email with such approval from your side. I am not sure why now is being challenged in any way. We need that agreement for our other shareholders in the venues. So you were insisting that from foreign investors, investment is required, and to show to those foreign investors these nominee agreements are needed. And that was what you told Mrs. Herz, that she should sign it for the foreign investors, but you will never use it against her. Did you not say this to her?
No, that's not correct. First of all, one of the arguments or one of the reasons why we requested to have the nominee agreements in place is for showing it to other investors, as I said, but it's also for a matter of corporate governance and to document the right process. So it's not solely to that reason. The second is we never say that those nominee agreements will not be enforceable or will not be implemented. So I don't know where you get that that information, but it's clearly not true.
You have read Mrs. Herz's witness statements, haven't you?
Yes, I did.
And she repeatedly said that you made these misrepresentations to her. And because of these misrepresentations, she signed the 2 nominee agreements. You correct me if I'm wrong. I haven't seen in any of your 5 witness statements that you deny these allegations of Mrs. Herz. Do you?
It's not a fair question, Mr. Iqbal.
I was going to just say that if representations are being, I'm sorry to interrupt, Judge, I think you've anticipated my question, but if representations are being suggested, which have not been pleaded in our submission, they ought to be put.
That question is disallowed, but you may want to rephrase it. So go ahead.
Yes. Okay. Well, you did not say before today that you did not make those representations to Mrs. Herz, did you?
I'm sorry.
I think we do need to be a little specific.
Mrs. Herz says that because you made these representations to her, she signed black tap nominee agreement, put it in her filing cabinet, and forgot about it because you told her that you had no intention to use it against her. Do you accept that this is what you told her?
I accept that that's absolutely a lie.
Fine.
I'm sorry. I think what she said was slightly different in my submission, and I don't think it was fair. Excuse me. I'm sorry to interrupt, but what she said was that in relation to the payment.
Wait a minute. I'm going to allow that if Mr. Iqbal has put a wrong question.
I can come back. Thank you.
Thank you. And I put this to you that it was because of your representations that you will not use these nominee agreements. She signed the brick oven agreement at a time when she did not hold those shares because she thought and she knew that these agreements will be useless anyway and they will not be used against her by you.
That is rejected. He cannot speak as to her mental processes.
I agree, yes. Okay. So you asked Mrs. Herz to sign brick oven nominee agreement on 25th of May 2017 when she did not hold shares in brick oven because you told her that you will never use this nominee agreement against her in any event, did you?
No, that's absolutely true. Untrue. That's a lie.
Thank you. Thank you. No problem. I'm moving on. If we go back to page number 380, please.
Yeah.
We're back to the heads of agreement, as you can see. And if I can draw your attention to number one, towards the end of the page, fixed fees and anticipated profit fees. Just take a moment to look at that, please.
Yep.
Now, you say that this agreement was not signed until April 2017, but this agreement was being actioned upon because you were making payments to Mrs. Herz under the fixed fees and anticipated profit fees as early as July 2016. Is this correct?
Yeah, that's correct.
Thank you. I refer to page number 598, please.
Yes.
This is a summary of the payments that you say you made to Mrs. Herz. Can you see that?
Yes.
Towards the end of the page, it's a table relating to 2016.
Yeah.
And July and August rows are left blank for invoice number, amount, status, but for September, October, November, December, we can see the invoice numbers and the amounts paid.
Yes.
Is that right?
Yes, correct.
So that means that even though you had not signed, as you say, the heads of agreement, but you were acting on the heads of agreement. Is that correct?
Yes, correct. Now, may I?
I have no objection.
What I'm not sure now looking at this, and again, this is 6 years ago, if the months of July and August were still treated under the previous commercial arrangement where we were paying sponsorship fees on a company by company, or they were already clubbed as the new agreement. I don't know if those is because we couldn't find the receipts and the payments done, or it was done differently. But as you can see here, all was executed around that time as per the head of terms.
Now, can I please refer to page 1864, please?
Yeah.
You can see.
There you go. Yeah.
Yeah, you can see that this is an invoice from Fixed Sense. The date of invoice is 30th of July 2016. Invoice number is 104. It's in the total sum of 61,000. Can you see that?
I can see it.
And on the next page, well, in fact, it's 1866, please.
Yeah.
And you can see that this is
the same for August. Yeah.
Yeah, this is the invoice for 30th of August 2016 in the same amount.
Yeah.
And they were paid, correct?
I'm not sure if they were paid. I'm not sure if this was an invoice. This, I don't know. This, our accounting will need to double check.
Okay. So, will you agree with me that on 1st of July 2016, the sunset event was still existing?
I don't remember. We'll need to double check that one. Sorry.
Okay. Just to refresh your memory, if I can make a quick reference to page number 1819, please.
So yes, if it was, I don't know, because this company was terminated after some time, but it seems that it was existing on the date that you mentioned.
Okay, so from 1st of July, Sunset Event Management was still operative, in which Mrs. Herz held 51% shares, and also Black Tap was existing by 1st of July, in which Mrs. Herz was holding 51% shares, and also heads of agreement was being acted upon. Do you agree with me?
I think the dates are correct as per the documents we have.
Okay, thank you. If I can please, with respect, trouble you to go back to page number 380, please, which is the heads of agreement.
Yes.
And you can see it's the bottom, towards the end of the page, effective date, that this heads of agreement shall remain in force for an unlimited period. You can see that?
Yes.
So let's say, and this is for argument's sake, if the nominee agreements were never signed, or if they never existed, then this heads of agreement, sunset event, and also black tap, those business arrangements would continue. Is that correct?
Well, what's the point of that hypothetical question, Mr.
Yeah, the point with that is that even if those nominee agreements did not exist, or even if they had existed, the business arrangement, i.e. holding the shares, receiving anticipated profits and fixed fee, would nevertheless continue.
That is relevant because the nominee agreements existed.
Well, my question is hypothetical. If it did not exist, would the business arrangement continue?
The question is rejected as irrelevant.
My lord, thank you. I'll move on. We are at page number 380 of the heads of agreement.
Please. Yes.
Now, you can see that this is in fact continuation from 379. This is about fixed sense services, the services that fixed sense would perform.
Yes.
The first one was holding 51% shares.
Yeah.
The second one was liaising with government and semi-government departments.
Yeah.
Third was representing Sunset Group. And fourth, developing the business plan, developing the business.
Yeah.
Mr. Ahmed Sandal, although 51% shares are not or were not registered in his name, could he not perform what is in B, C, and D?
I don't understand the question.
Fine. Even if Mr. Sandal did not hold 51% shares in Brick Oven and Black Tap, could he not liaise with the government and semi-government authorities, represent Sunset Group, and develop the business? Could he do that without holding those shares?
Again, I don't understand the question.
Okay, I put this to you. Yeah, I put this to you that in order for someone like Mrs. Herz and Mr. Sandal to liaise with government and semi-government authorities, to represent Sunset Group, and to develop the business, it's important to hold the shares first, and only then you can perform these services. Is this correct?
No, I don't think that's correct.
Why not?
Employees don't hold shares in the company, and they represent the company in the daily matters of the operations. And I don't understand the connection between one thing and the other.
Right. And just last question, and then I'm moving on. So Mr. Sandal did not liaise with government or semi-government authorities did not represent Sunset Group and did not develop business because he did not hold the shares. Is this correct?
I don't know.
That's fine, no problem. I'm moving on. If we can go to page number 560, please.
Yes.
This is the second witness statement. And paragraph number 11, please.
Yes.
The first sentence, the point being, of course, that a true partner and / or shareholder does not receive compensation for acting as a shareholder. A true and fully paid up shareholder receives a share of profit by way of dividend. You can see that?
Yeah.
And if we then turn to paragraph number 17 on page 562, please.
Yes.
And this is here where you have mentioned certain payments made to Fixens. Can you see that?
Yes.
And then in paragraph 18, you say the anticipated profit fee was an advance dividend.
Yes.
So when she was receiving dividend, how come you can say that she was not a true partner or a shareholder?
Yeah, Mr. Iqbal, you're mixing different things here. And if I may elaborate on this, please. Where I was referring that as a local sponsor in the LLC entities, she was never a true shareholder, and therefore she was never paid capital, she was never acting as a shareholder, she would never receive dividends or in any way was a shareholder, as I made clear before. That is clear for the LLCs. What we are referring here, when we move from local or ad hoc agreements on the LLCs to a bundle agreement under the head of term, in that head of term, we agree a few things. One is that they will have a fixed compensation on a monthly basis, which I recall 40,000. And because Hana and Marwan, and therefore Fixens, wanted to have further involvement in the business of Sunset, we will, part of that head of terms, we will grant them 2.5% shares on our holding company, Sunset Ras Al Khaimah. Don't know the surname, but it's the entity registered as Ras Al Khaimah. Under that agreement, we were paying them that fixed fee and 2.5% of the shares. At that time, their concerns were like, we are not involved, we are minority, we're only going to have 2.5% of the company. How we can ensure that we are continue receiving enough funding for as we were before as a local sponsor. And we agreed to guarantee a certain amount of dividends or payments or profit in advance. Because at that time, they were really shareholders of 2.5% in that Sunset track. And that's the 21,000 amount that we were paying over a period of time. So that's what it refers to when I'm talking about anticipated profit fee. So that shouldn't be mixed with the profit fee of the LLCs or the Dubai Economic Department companies.
Would you agree that by that time, that's in July 2016, Mrs. Herz was providing services under Sunset Event Management? Is that correct?
She was providing services?
Services under Sunset Event Management.
I don't know.
Well, why don't you know?
I don't understand the question you're asking. If she was providing what services and in what time?
Well, consulting services, operational services, and she was a shareholder of 51% in Sunset Holding that is why she was being paid this dividend. Isn't this the truth?
No, that's not the truth. As I said, we have Hana and Fixens as a local sponsor of some of the
Okay,
companies.
I'm very sorry. I'm very sorry because I think the screen were frozen for a moment or two. I therefore could not understand the start of your sentence. I don't know whether this happened with everybody else or not.
Okay, may I repeat that again? Hana or Fixens, or the combination of both, had an agreement with us for sunset event management where we were paying them a sponsorship fee on sunset event management. That sponsorship fee was then transferred into the head of terms, okay, together with the new companies that we incorporated, like Blacktap and Brick Oven. So I don't know. I think it was until the 1st of July. I think they were compensated for their sponsorship and the sunset event management, and thereafter they moved into the head of terms, as per the commercial arrangement that I explained, and that is clearly specified in the head of terms.
Do you still have paragraph 11 in front of you now?
No, but I can put it. Can you put
Okay,
11?
page 560, please.
Yeah.
And
Yes.
in the last sentence of paragraph 11, you say the defendant or Fixens, for that matter, has never invested any capital in any of Sunset Group companies. You can see that?
That's correct.
Can I please refer you to page number 788, please?
Yeah.
And you can see that this is a check dated 8th of June 2014, payable to Liz Riachi in the sum of 450,000 dirhams, and the check is from Mrs. Al-Herz's account. Is that your understanding too?
It's from Fixens Management Consultancies.
My apologies. Yes, Miss Hana Al-Herz's signatures appear underneath. So, but you agree that this is the check issued by Fixens for that amount?
Yes.
Mrs. Al-Herz says that this was her contribution or her investment into the business, and you disagree with that, don't you?
That's a total big lie.
And if you're still on page 560, if you go back to the previous paragraph of paragraph 8, please.
Yes.
And there you mentioned that Fixens requested an upfront fee of 500,000 dirham plus 300,000 annually in relation to Grand Hyatt / China. You can see that?
Yes.
Okay, just 1 second, please. If we can now please go to page number 1103. This is your third witness statement of 15th of March 2021.
Mm-hmm. Yes.
I would just ask you to please take a moment to read for yourself paragraph 62 to paragraph 64, please.
I'm sorry to interrupt, Mr. Iqbal and Judge. If you could please start with paragraph 60, I think that might just help save time.
Absolutely fine.
If you could, from 60 onwards, please.
Yeah. Yes.
Yeah, wait, I'll wait for the judge to complete reading.
Yeah, go ahead.
I'm grateful, thank you. Now, if you can please turn to page number 1719. This is your fourth witness statement, please.
Yeah.
And here, I refer your attention to paragraphs 4 to 7. Please take a moment to read them.
Yes. I'm familiar with this.
I'm grateful, thank you. Just wait. So, what you say that this 450,000 dirham was in fact part of 500,000 dirham that Fixed Sense received as a custodian. That's what you say, isn't it, in a nutshell?
Yeah, that's the truth.
And if I can show you page 1153, please.
Yes.
And this is the invoice from Fixed Sense, dated 28th of May 2014. And it's issued to Antonio Gonzalez, Preside General Trading LLC. And we can see two different sums, 500,000 dirham and 300,000 dirham, and total of 800,000 dirham. So this is the invoice that you were referring to in your witness statements. Is that correct?
Correct.
Thank you. If we can go back to your third witness statement at page number 1103, please.
Yes.
It's paragraph 62. I'm back to that.
Yeah. Can you put 62, please? Yes.
What I understand from here is that your friend Manuel Ayaz, he introduced an investor, Purzai, to fund the project. For the project was, what was this project? Was it Provocacho or
Yes,
what?
correct.
Provocacho, okay. So Manuel found this investor, and Manuel wanted to charge Purzai a finder's fee, correct?
Yes.
But Manuel didn't want to tell Purzai that Manuel wants a finder's fee, correct?
Correct.
So he suggested that Fixed Sense could charge this finder's fee
On our behalf.
under their invoice and could receive this money, right?
Yes.
And then you would pay 50,000 dirham to Fixed Sense and get 450,000 dirham back from them.
That's correct.
And then you will share that money with Manuel.
Correct.
Okay. And paragraph 64, you say that Manuel did not want to receive this money directly from Fixed Sense, as he was worried that Purzai would find out about it, correct?
Correct.
And that's why the money was arranged to be sent into Liz's account.
Yes.
Okay. It sounds to me as if Purzai was either being tricked or was not being told the truth about the invoice from Fixed Sense? Is that what you want us? Is that what you are telling us?
I don't know. I don't know what to answer to that. I don't know if it's trick or not. They were charged a fixed fee, a channel through Fixed Sense, and then paid back to us.
Is it correct to say that in order to enrich yourself and Manuel and to get money out of Purzai, you used not only Fixed Sense, but you also used your wife Liz's account? Is that correct?
We use Fixed Sense or we asked Fixed Sense to charge that fee, and they accepted, and they did for that. And part of the arrangement that they will keep 10% of that amount, the 50,000, and we use the account of my wife Liz to receive the payment.
And you say that this money was received by Fixed Sense as custodian.
In a way, yes.
Is there any evidence, any documentary evidence to show that Fixed Sense received this money as custodian?
I don't think we have a specific document that we hire Fixed Sense as a custodian. These were all verbal conversation and agreement that we have with Hana at that time. But as I think, I don't know if it has been filed as a proof or not, but Patrick can elaborate further on that. We have an agreement to pay through the provocateur setup to that company setup, a sponsorship fee to Fixed Sense, and also revenue sharing model that they were taking a percentage of the sales, and also to the person that was acting on kind of intermediary for them as well, a gentleman called Harry Selwood. So those agreements were in place, and at the same time, where we received those agreements, we received the kind of a sponsorship agreement from Fixed Sense, where you can see very clearly that the arrangement was only for 300,000, and there was no mention of the 500,000. The 500,000 was added later, as per our request, to channel this finder's fee. So that's the only kind of reference that I have, where we received the proposal from Marwan for 300, and then after talking to them, we asked them to top it up and put another 500 on top. That was done in the invoice and in the final agreement raised with Purzai, and that's how it went through. The first set of documents were addressed to Giles, but Giles was at that time was an SPV that was not dedicated to this, and the final agreements were arranged with the investment company, and in those you can see that while the initial amount was 300, after was 300 plus 500, as per our request.
Am I right in understanding that both you and Manuel collaborated together to hide from Purzai that you were going to receive that 500,000 dirham, which Purzai was paying to Fixed Sense as a finder's fee? Is that correct?
It's relative. It depends on the wording how you put it. I see a different way. There was an opportunity to charge a finder's fee for that work. We didn't want it to come from our side, and we asked Fixed Sense to charge it and give us part of that revenue.
You accept that you were not upfront and straightforward with Purzai?
That's correct.
And you also accept that you are not upfront, you were not upfront with Mrs. Herz as well when you asked her to sign the nominee agreements, because you made misrepresentations to her that you will never use those agreements against her. Is that right?
That's not correct. And once again, I want to reiterate something. When it comes to Purzai, we never made a representation to Purzai in one direction or the other. Okay? We saw an opportunity to create revenue for ourselves and for Fixed Sense, which also kept 50,000. just for being at intermediary on that operation. But we were never misrepresented our intentions to anyone, not to Hana, not to Fixsense, or not to Pursai in that matter.
But you did not disclose to Pursai that that 500,000 fee was not a finder's fee. It was something that you would get through Fixsense.
It was a
Right.
finder's fee.
But you didn't tell Pursai about it.
We told them that that amount will be charged by Fixsense. We didn't tell them that part of that will be shared with us.
If you had told Pursai that you and Manuel would be ultimately receiving that money and sharing between yourselves, what would happen?
I don't know.
Pursai would not make that 500,000 dirham payments, correct?
I don't know. You're speculating.
And you would lose on that money, correct?
Again, I don't know. You're purely speculating.
So through this arrangement, as you say, using Fixsense, using your wife's account, Liz Riachi's account, and then sharing the money, you effectively put a trap for Pursai, did you not?
No, we didn't put any trap to anyone.
And then you also and then you put a rather different trap for Mrs. Herz when you asked her to sign those nominee agreements. You
We
accepted?
have never put, again, let me repeat again. We have never put a trap to Pursai, to Fixsense, or to anyone.
Ms. Herz denies what you say in relation to this 500,000 dirham payment and your assertion about custodian. You mentioned that it was discussed with Fixsense in verbal conversation. Is that correct? Is that what you said?
Correct.
I have seen that there are a number of emails in which your verbal communications were reflected. For example, that 100 dirhams or 10,000 dirham for black tap nominee agreement. So this custodian arrangement, 500,000 dirham, was it ever reflected in any of the emails?
Sorry, I don't understand the question.
Fine. You say that this 500,000 dirham was discussed between you and Hana in verbal conversations.
Yes.
And I say that previously you had exchanged emails with Hana in which you talked about speaking with Hana about black tap nominee agreement, raising the compensation from 100 dirham to 10,000 dirham. So when you had communications, verbal communications, reflected in your emails about black tap, did you have the similar emails about this 500,000 dirham payment?
I lost you on the whole question. I don't know if you can be more specific what exactly you're asking, because I don't understand it.
I put it straightforwardly.
Please.
This whole story of 500,000 pounds that you say Fixsense received as a custodian, you just created it to defend Mrs. Herz's claim that she paid 450,000 pounds as a capital contribution. You just created a story, did you not?
No, of course I didn't. Our witness statement and what I've said is absolutely true. There is no ambiguity on what I've said. And on the other side, what Hana has expressed is an absolutely blatant lie.
I have shown you 8 different agreements. Heads of agreement, shareholders agreement, sunset event management MOA, black tap MOA, black tap nominee agreement, brick oven MOA, brick oven nominee agreement, And now this £500,000 you say is relating to provocateur. Why is it that in almost every agreement, there is something that does not reflect the reality, as you say?
I think all the agreements reflect the commercial reality in one way or the other, and that has been executed in a practical matter. When you ask me, first of all, to clarify, it's not £500,000, it's 500,000 dirhams.
My apologies, yes, 500,000 dirham, yes.
We have explained and illustrate very clearly where that 450,000 that we received payment for, where came from. After that was an insinuation of that lie that was paid as a capital. We explain exactly what that amount was for and what the background story of that and how it's used and all of that very clearly. And that's the absolute truth. What is a total lie is that Hana, Fixed Sense, or Marwan in any shape or form have ever contributed to equity on any of our business.
My lord, at this stage and in view of the time, and given the fact that we have been 2 hours into the cross-examination, might I respectfully ask either your lordship would agree to my respectful proposal of taking an early break, which would enable me to go back to those instructing me for 2 reasons. One, to see if there are any further areas they want me to explore. And number 2, what is my instruction in relation to that application, the one that we have talked about before?
Subject to instruction, you contemplate you may have finished your cross-examination.
Subject to those, when I return, I do not anticipate I would be any longer in my cross-examination. I have almost come to a close, but I do not wish to formally close it before going to those instructing me.
Yes, all right. Well, it may be convenient. Mr. Dillamano, does that seem a convenient course?
Yes, indeed, Justice Giles. I think we didn't have an opportunity to explain to Mr. Gonzalez the protocol and duty that he has, and so you may wish to just mention that to him.
Yes, all right. Well, so is the intention we might take, Will, for you, or at least for those in Dubai, be a luncheon break, I take it?
Yes.
So what sort of luncheon break? Do we need to make it shortish or
yes, I mean, I think Mr. Iqbal has made good progress, it appears, and we have Mr. Spiliopoulos ready as well. But I think he is in London and will be available shortly after the resumption, hopefully. I have maybe 6 points in very brief redirect, but I would hope to be quick on those.
I wouldn't expect either Mr. Spiliopoulos or Mr. Kamaluddin, sorry, I may have mispronounced that, to take very long. How long do you think?
Well, I'm going to be fairly quick with him. I don't know how in terms of minutes, but I'm going to be absolutely quick with him.
Well, the way it's looking, we're going to be able to get to Mrs. Herz today. Is she available?
I beg your pardon, I just didn't hear that correctly.
Well, the way it is looking, we would be able to get to Mrs. Herz today. Either that or we take an early break. Is Mrs. Herz available to start today? And Mr. Dillamano, are you ready to start?
Well, first, Miss Herz's availability. The answer is yes, she is available. Regarding whether Mr. Dylan Malone is ready or not, I will wait for his reply. But I would submit that we should discuss Miss Herz's readiness to give evidence once we are done with Sunset's case. because by that time we would know how long we are still left in the day today. I do not wish to go part heard with her evidence, because that would prohibit me to speak with her, communicate with her, because she would be in the middle of her evidence.
Yes, and that's right. You wouldn't be able to speak to her, but we would at least use the time. I'm going to take a break now, and it's the luncheon break. It will be for 3/4 of an hour. We'll resume in 3/4 of an hour, and I would expect you and Mr. Dillon Malone to spend at least 5 minutes of that time discussing the future, because I would expect that if time permits, with the normal 6-hour day, we will start with Mrs. Herz and get as far as we can with her.
Very good, Judge. Could I just to inform our discussion, and in the light of what Mr. Iqbal has said, it would be out of sequence, but in the light of what you mentioned on our openings, I don't know whether there's it would be an alternative to address you in relation to some of the legal issues. We could use the time, and it would be out of sequence. But I don't think that's very normal, and even trying to formulate it, I don't think it works. So
that would work.
Yeah.
Right. Now, Mr. Gonzalez, you're under cross-examination. What that means is that during the break we're about to have, you must not discuss the case or the evidence you're about to give with anyone else. All right? None of your legal advisors, no one else. You talk about the weather or the football or something, but not the case. All right?
Understood.
All
Yes,
right.
sir.
So it would have been for 3/4 now.
Yeah, so that just we're absolutely sure, because of the time differences in different places where we are, I want to be absolutely sure what time we are coming back. If I can know the exact time from Dubai time we need to come back.
Well,
Well, it would be
let us
1:35. Excuse me,
Yeah.
Judge.
Let's make it slightly longer. Let's make it 1:45 Dubai time, which will be 8:45 my time. And Mr. Iqbal, what is that your time?
That would be 9:45 London time.
Right. All right. We now all know exactly where we are. So at that time, we'll return until then.
Thank you very much, Justice.
Thank you.
General.
Grateful. Thank you.
Yes, Mr. Iqbal, are you back with us?
Good afternoon, my lord. Yes. First, my lord, I'm not addressing you on the alleged application for summons. I'm leaving it to one side.
Thank you.
Secondly, I have spoken with my learned friend about the time that we can best utilize this afternoon. I am happy if we are left with enough time after completing Sunset's case to start with Mrs. Herz's cross-examination today, her evidence today. If by the time that we are done with Sunset's case, we shall see what time the clock would strike at that point. If there is limited time left, say 15-20 minutes, it would then be my view that it's not sensible to proceed with her evidence today, and we should rather leave it for tomorrow morning. But if there will be ample time, then I see every reason to encash that time, and I will put her to give her evidence today.
All right, we'll wait and see where we are in cross-examination of the further witnesses.
Okay, can I extend my apologies? I think just because of the intermittent communication delay, there are a couple of words perhaps that I could not understand your lordship said, so I couldn't understand the full sentence.
Let us wait and see how the timing is when you have finished your cross-examinations.
Absolutely, I'm grateful. Thank you.
All right. Well, will you continue with whatever there is left of your cross-examination of Mr.
Yes.
Gonzalez?
Almost coming to a close, except one or two questions. If I can please refer Mr. Gonzalez to page number 1819, please.
Yes.
I think I have already shown you this page, which relates to Sunset Event Management, in which Mrs. Herz was holding 51% shares, and we can see that this document print date is 15th of March 2018. Having seen that, let's go to please page number 1826, please.
Yes.
Well, in fact, just for the sake of completeness, let's have a quick look at page 1824, because that's where this document starts.
Yes.
And you can see that this is the commercial license for Sunset Event Management. And here we can see the print date, bottom left-hand corner, is 7th of July, 2021. You can see that?
Yes.
And if we turn to page number 1826, please.
Lower on the print date. Yes, I can see the
Yeah,
print date, and
yeah.
then what do you want to show?
Yeah, then it's page 1826, please.
1826. Okay, yes.
And again, it's the same company, Sunset Event, but here, what is different? That Muhammad Saleh Ahmed, he seems to have replaced Mrs. Herz, and it is Muhammad Saleh Ahmed who is now holding 51% shareholding. Can you tell us what happened to Mrs. Herz's shareholding in Sunset Event Management?
Well, she was replaced with another local sponsor.
And she was replaced because you had used a power of attorney that Mrs. Herz had executed in your favor on 5th of May 2014. Is this correct?
That's correct.
So using that power of attorney, you brought Mrs. Herz's involvement into Sunset Event Management. Is this correct?
I brought to the end at that time the change of a sponsor, yes.
And when did you bring, if you can recall month and the year, that will be helpful. So
I'm
in
not
which,
sure.
yeah, roughly, and I don't ask for the exact dates, roughly which month and the year did you bring Mrs. Herz's involvement as 51% shareholder in Sunset Event Management?
I'm not sure. I think we'll need to check the exact date and get back to you on that.
Was it in middle of 2021?
Again, I'm not sure. We'll have to. I don't want to speculate without knowing the exact information.
But it was certainly after this dispute had started. Is this correct?
I don't want to speculate. I want to tell you the exact dates. But I'm not sure. To tell you the truth, I'm not sure.
Is this correct that you used Mrs. Hana's power of attorney as a retaliation for her refusal to abide by the nominee agreement for Brick Oven and Black Tap?
No, that's absolutely untrue and false. The power of attorney that we have on sunset event management was the tool that we had at that time to kind of hold the shares of that 51% local sponsorship on sunset event management. We didn't have a nominee agreement for sunset event management. We had that power of attorney that allow us to use the share, dispose the shares, and take action on those shares. We used that power of attorney to change the local sponsor. I can also confirm that Hana kind of filed a claim in Dubai court because that power of attorney was regulated under Dubai courts, and Dubai courts dismissed the claim of Hana, saying that we acted as per the law and according to the agreements in place. So we changed the local sponsor. We never retaliate. We never took any action. This is a simple change of local sponsorship as per the agreements that we had in place.
Is this your recollection that in May of 2014, Mrs. Herz signed this power of attorney in your favor because Mrs. Herz was traveling to different places with regards to her medical treatment? Is this your recollection too?
Not at all. Ms. Herz signs the power of attorney because she was a local sponsor and she has no rights to the shares.
Is there any particular reason that you did not have a similar power of attorney in relation to Black Tap and Brick Oven?
No specific reason, because at that time we were having also the head of terms agreement and we would have the nominee agreements. We were also using different lawyers at that time. When we did the sunset event management, we were working with a local law firm that they used the power of attorney. As we move into the nominee agreements and the head of terms, we use a international law firm, Curtis, based here in the IFC, who articulate all those agreements, and they recommended to proceed like that.
I suggest that you did not have power of attorneys for Black Tap and Brick Oven because Mrs. Herz refused to give any more power of attorney, and as a result, you made misrepresentations to Mrs. Herz, and that's why she signed the nominee agreements. I suggest this to you. Do you agree with me?
No, that's totally untrue and false.
Thank you. I'm grateful. No further questions from me.
Thank you, Mr. Iqbal. Mr. Dillman, re-examination. You're on mute.
Apologies. I'm speaking now. Thank you. Thank you very much, Mr. Gonzalez. There are, I think, 4 short areas I just want to ask you about on re-examination. Sure. The first is at page 595, please, of the bundle. And you were asked, was there any documentary evidence sorry, I'll just find the page myself, excuse me. Any documentary evidence of the taking effect of the agreement from the 1st of July 2016? And if I could just ask you to read the email starting "Hi Antonio," occupying most of that page.
Yeah, you want me to read it, Patrick?
Just to yourself, please.
Mm-hmm.
And you'll see that there's a reference after the quote where the cross-default language is set out by Mr. Lutfi, that Mr. Lutfi suggests that it should be the 1st of July 2016, as that is when we switched to the 61,000 fees in replacement of all other fees and in anticipation of this agreement. Is that Yeah, and that is a written document as per the question that was asked of you.
Yes, that's correct.
In relation to the question of whether there was any documentary evidence of the raising of the amount of the fees under the nominee agreements from a small amount to a higher amount, can I ask you please to go to page 523 again?
Yes.
And you'll see this is a email from you on the day that the Black Tap agreement was entered into, the 18th of December 2016.
Yes.
And you're enclosing the nominee agreement. And if I could ask you to read the second short paragraph. As agreed yesterday, we've changed the sponsorship amount to 10,000 dirhams. However, also as agreed, we acknowledge that this is symbolic and we'll still need to find a final agreement over this, whether in the form of a shareholder in Sunset Group or an agreement for this outlet.
Yeah.
And was that letter evidencing the what happened between you on the question of how much should be paid and how much the fee should be indicated in the nominee agreements?
Yeah, correct, exactly.
And in that respect, could I ask you then please to go to page 861? Can you pull up 861, please?
Sorry, that's 861, did you say?
861, yes.
Thank you.
And you'll see there's a long, it's paragraph 40 of I think it's the fourth witness statement of Ms. Herz. And about halfway through that paragraph, you see a reference to 100 dirhams, and that will help you find the sentence. You see, she says, I also highlight that although I understood that the fee of 100 dirhams was only symbolic, presentational, it was degrading for a local partner to be contracting for such sums. I made it clear that I needed to be properly compensated. Antonio agreed to increase the amount in the agreement. However, he continued to say this was symbolic. Antonio made clear, and I understand the fee written down in the nominee agreement was not the true compensation that I would receive for acting as a local sponsor, and that my interests in relation to my shareholding would be recompensed by alternative arrangements. And then he spoke about figuring out an arrangement. Does that statement of Ms. Herz in her evidence accurately reflect the position?
Yes, correct.
Yes. And then if I could go to the third area, at page 598, this just arises from something that you said. This is the table of payments, which Mr. Iqbal referred you to.
Mm-hmm.
That page 598.
Yes.
And I'm not asking you to look at it, but I just want you to comment, please. You said the following, I have a note of it, towards the end of your evidence on the table. You said, these were all executed around this time as per the heads of terms. What did you mean by that when you said all executed?
Is that they were paid. They were effectively transferred and paid.
Thank you. And then if I could ask you, please, the next 6 questions I'm asking you are my last questions, and they relate to 2 areas that you were asked about at the conclusion of your evidence. They related to whether there was documentary evidence of the true purpose of the payment, of the check, the true purpose of the check, and whether there was any communications, email communications, between you and Ms. Herz in relation to these. And I'm going to bring you to a sequence of documents, and if you could please bear with me.
Sure.
First of all, 1889, please, if we could, can I just ask you to do this, please? 1889. This is your evidence
Yes.
in your final witness statement, I think. And if I could just bring you to paragraph 4. You say, at
Yes.
paragraph 9, I mentioned 3 documents relating to Callus. I wish to clarify that the consulting agreement exhibited at 9C was amended to include the upfront fees of 500,000 dirhams, the success fee, as explained at paragraphs 5 to 7 of my 4th witness statement, which was apportioned between Fixed Sense, Manuel, Ayas, and myself. Additionally, I now exhibit the signed versions of the revenue sharing agreements previously exhibited at 9D and 9E of AGO4. Now, I will bring you in a minute to the ones you exhibited in your 4th witness statement. I just want you now to look at page 1891, please.
Yeah.
Jonathan. 1891.
Yes.
And here, this is the signed agreement. It's dated the 3rd of December. You see the top of the page. It's dated the 3rd of December. And it's between Callus and Fixed Sense. And this is an agreement between you. And if I can then refer to page 1896. There's a scope of services set out in relation to provocateur and the opening of provocateur, and the elements of the services are indicated.
Yeah.
And then at page 1896, sorry, on the next page, yes, 1897, you have the compensation terms.
Yes.
And you'll see at point 1, there's a reference to 500,000 dirhams payable as success fees upon completion of the services in Exhibit A. And then down below, 300,000 dirham annually for the duration of the agreement. Do you see that?
Yes.
Yes. And do you remember this consulting agreement?
Yes. Yes. Of course.
I think you said in your evidence that you weren't sure whether there was any reference. I think you said that there wasn't a reference to the 500,000 dirham in any agreement. Could you comment on that now?
No, what I mean is the original proposal that we received from R1 for the set of arrangements and the provocateur didn't include that 500,000.
Okay.
It was upon our request that was included. So I think we have an email from R1 where we received those contracts and that clause is not there. Then we asked for it and the final executed contract include that clause.
Thank you. And I think
I was trying to make the point that it was not their intention to charge that. We asked for it and then it got charged.
Very good. In that regard, and this all arises, Justice Giles, could I ask you please to go to the unsigned agreement that you refer to? It's the unsigned consulting agreement.
Yes.
Behind AGO4. Excuse me, I'll just find that page number. I've lost my reference page here. Excuse me. It's on page 1743.
Yes.
See, and so on 1743 you have the same agreement. Then at 1748 you have Exhibit A.
Yes.
And then on 1749 you have Exhibit B. And if I could ask you to please look at that.
Yes.
And you'll see at 1A there's a reference to the 300,000 dirham.
Yes.
Is that the original proposition that you were referring to?
Exactly. That's the first proposition we received from R1. And then we asked to add the 500,000 on top. And that's the one that was signed.
Thank you. And they were both dated the 3rd of December, 2013.
Yeah.
Now, could I ask you please to go to page 1884? And I say all of this arises because it was suggested that there wasn't any record of supporting your account of the true purpose of the check. Yeah. I just want to bring you to a sequence of documents starting at page 1884. This This was open to you. You see underneath the bit in bold where it says contract number, it says project Provocateur Lounge and Club. You see that?
Yes, correct.
And then above, underneath the date, there's a reference, FS CSI 14-02. That's right at the top of the thing. And
yes.
Now, if I could ask you to turn, please, to page 1154. You'll see this is National Bank of Abu Dhabi. It's a payment funds transfer request dated the 31st of May 2014. That's underneath the in the first row in clear row, and down below about 1, 2, 3, 4, 5 boxes down on the right hand side, you see the reference number FS CSI 1402.
Yes.
And yeah. And at page 1155, then the next page, this is an email from who is Faisal Pudanham?
Yeah, he was the finance person working for the group, which is part of one of the sister companies of Pursai.
Thank you. And this is please find the attached funds transfer advice of 800,000 dirhams for Fixed Sense bank account, and the reference number is there again on the first line of the email.
Yes.
And it also says consulting fees as per section 1 and 2, exhibit B of contract number.
Yes.
You see that? And I think we've just seen sections 1, the exhibit B was referred to also in the invoice from Fixed Sense.
Yes.
You can see that in terms that the 500,000 and the 300,000 on page 1884. We might just pull that up again. 1884. And we see in the boxes where the amounts are described, where the description of the services are provided. You've got in number 1, exhibit B of the above mentioned contract, 500,000 dirhams, and exhibit B of the above mentioned contract is section 2 for the 300,000. And that's correct, isn't it?
Yes.
And then finally, we'll turn please to page 1158. And the question was asked of you as to whether there was any emails supporting the payment or the existence of the payment, which from Ms. Herz or from Fixed Sense to you for the Provocateur payment. And this is an email exhibited, sorry, this is a WhatsApp message dated the 1st of June 2014. Who is that from?
This is from Hana to me. I think it's a text message, not a WhatsApp, but it's a message that I received from Hana.
Oh, I see. It's not a WhatsApp then. It's a text on your telephone.
Exactly.
Yes. She says, just wanted to let you know the payment received. So that's one day after the payment receipt.
Exactly.
And then she goes on to say, if you're still alive, please call me. Can we just scroll down a bit?
Can you scroll down?
And then she is trying to establish when you might talk, I suppose. And then on the following page, she says, is that this one, the 5th of June 2014? Who is this message from?
Also from Hana to myself.
And it says, send full name for your payment. Anyway, it is safe until you decide. What did you think she meant by that?
No, at that time, we didn't confirm to her to which person would be transferring that 450,000. And by that day, we told her that would be going to my wife. That's
okay. Very good. And it says, do you want it today or Sunday is okay? And you say Sunday is fine. Is that right?
Yes.
And Sunday, it was the 8th of June 2014. Is that correct?
Yes, correct.
And did you receive any other payment of 800,000 dirham or any other payment from Ms. Herz on the Sunday, the on the 8th of June.
We received the check. You see here, the check is ready. So on the 8th of June, we collected the check for 450,000. And we deposited on my wife account.
I see. Thank you.
Yes, that's the end of the re-examination.
Yes, thank you, Judge. Thank you very much.
Yes, thank you, Mr. Gonzalez. May I release Mr. Gonzalez?
That's right.
Don't see why not.
Yes.
Thank you, Your Honor.
Yes, you're free to go as a witness. Thank you, Mr. Gonzalez. All right, well then...
thank you very much.
According to the plan, it's Mr. Spiliopoulos. Is that still the plan?
Yes, I believe Mr. Spiliopoulos is in London. I believe he's ready. Is he? He's. We just contact him again now.
Hello.
Hello, Mr. Spiliopoulos.
Hello there, Patrick. How are you? Lovely
Thank
to see
you very much. Now, you are in court, Mr. Spiliopoulos, and we're very grateful to you for coming. There will be a process now where you are sworn in, and then we'll take it from there. Thank you.
Yes, Mr. Spiliopoulos, it's the judge here. Can you hear me all right?
I can hear you well, Your Honour.
Thank you. Charla, would you mind swearing Mr. Spiliopoulos, please?
Yes, Your Honor. Do you want to please state your full name and occupation for the record?
Chris Spiliopoulos. I'm a CFO.
Please confirm if you would be swearing on a holy book today or affirming.
A holy book.
Okay, please raise your right hand and repeat after me. I swear by Almighty God to say the truth and nothing but I swear by the Almighty God to say the whole truth. I apologize. I swear by Almighty God to tell the truth, the whole truth, and nothing but the truth.
I swear by
The Almighty God to tell the truth, the whole truth.
The whole truth and nothing but the truth.
Yes, thank you.
Thank you, thank you, Mr. Spiliopoulos. Mr. Dylan Malone will ask you some formal matters, and then you'll be asked questions by Mr. Iqbal.
Thank you very much. Mr. Spiliopoulos, you've sworn one witness statement in these proceedings dated the 14th of March 2021. It's at page 1069 to 1071.
Okay, yes, that's correct.
Yes, and can I ask you please to look at the signature on page 1071 of the bundle? It's just the third page of your witness statement.
I'm looking at that now.
Thank you. And can you confirm that that is your signature and that the matters referred to in the witness statement are true?
This is my signature, and the matters in the statement are true.
Thank you very much. Mr. Iqbal will ask you a few questions. If you please answer them.
Thank you, Mr. Iqbal.
Thank you. Please refer to paragraph 12 of your witness statement.
Paragraph 12. It's in point 12, is that correct?
Let's call it point 12. That's on page 1070, the very last paragraph.
Is that state fixed and simply delayed for more than 2 months?
That's right. Yeah.
Fixed and simply delayed for more than 2 months after the accounts were provided, perhaps on misperhaps that they were allowed to pay LC, which expecting. Yep.
So when you say another Dubai LLC company, does it mean Sunset Event Management?
Let me just recollect. Just let me read that one more time. Yep, perhaps. Was this we had provided the Sunset RAC, the Ras Al Khaimah Incorporated company, so perhaps they were expecting another Dubai LLC.
You emphatically said perhaps. Is this a complete guess, or are you sure that it relates to Sunset Event Management?
I'm not sure. No, there could be another LLC within the group. That could have been one of the listed LLCs in the consolidated accounts, of which Sunset Events Management is one company.
So when you wrote this, is perhaps on the misapprehension on part of Fixed Sense that there was another Dubai LLC company. Which company did you have in mind when you were saying another Dubai LLC company?
No specific company.
Okay, thank you. I have no further questions for you.
Thank you.
It's difficult seeing the re-examination, Mr. Dillon.
Yes, in the speed of it, I have not put my finger on the specific sequence of emails that relate to this question that's been asked. If I could just please ask the court to bear with me for 30 seconds.
Yes.
Thank you. I'm very sorry, Judge. Excuse me, Mr. Spiliopoulos. If I could please ask you first, you keep that to page 1102. And here we have it's the witness statement of Mr. Gonzalez. dated the 15th of March 2021. And if I could refer you to
So what page was that again, please?
1102.
110. Bear with me, it's a large document.
And at paragraph 55, towards the bottom of the page, it says, in fact, as late as the 12th of November 2019, Fixed Sense's legal representative was still requesting the accounts of a company supposedly called Sunset Hospitality LLC, which is absolutely no relevance to Sunset RAC, if it even exists. And I'll just refer you to that. Perhaps you have you read that statement of Mr. Gonzalez?
Just bear with me. I'm trying to find this page. So it's 1102. 0102, and it's marked. Okay, and paragraph, please.
55. At the very,
Okay.
just the last sentence towards the bottom of the page.
Greatest difficulty in seeing that this is re-examination. It's an address.
Well, I think that the question was asked as to whether there was a reference to Sunset Events Management. Mr. Spiliopoulos said...
He was asked what was in his mind. He said no particular company was in his mind. That's it.
Very good, Judge. If you prefer that I don't continue, I was going to refer him to the actual email that refers to this particular company, but I can do that again.
I don't see that referring him to this paragraph is
It's page 83. Yeah. Okay. Well, the same point is in the other document. I won't take him to it, Judge. Thank you very much. Thank you, Mr. Spiliopoulos.
Thank you, Mr. Spiliopoulos. You're free to go as a witness.
Thank you very much.
Thank you. Thank you very much for coming.
Well, gentlemen, the next on the list is Mr. Kamaluddin, I beg your pardon. He's going to be talking about UAE law. Let's just have a moment's discussion about that, please. My understanding of the position is that UAE law is not a fact in this jurisdiction to be proved. It is something which, at least in theory, I know and am addressed on, but the reality is, of course, that I need help with it. That does not mean that the witnesses are cross-examined, as I see it, as if it were a fact. Through these gentlemen, maybe I can be provided with some assistance, which equally you gentlemen can provide to me in addresses. So what I don't want to see is a contest over addresses through the witnesses, if you understand my point. They can put materials before me, but so far as they express opinions on what the legal position is as applied to the facts, I don't think that is really appropriate, unless either of you wants to argue otherwise. Where that actually leaves the cross-examination that either of you has in mind of the opposite number, I'm not entirely sure, but that's why I wanted to have this discussion.
Thank you very much, Justice Giles. If I may go first, subject to Mr. Iqbal, I think I foreshadowed it in something I said in the opening. Mr. Kamaluddin made a short witness statement as a responsive statement to Mr. Nazar's statement. They are not witnesses as to fact, and nor are they expert witnesses pursuant to Part 31, so it's quite unusual. Certainly for my part, I'm not sure if I will have any questions for Mr. Nazar. We intend to address you in closing on the UAE law aspect by way of submission. I also have Mr. Ali, Mr. Mossab Ali, who will be, with your permission, might address you directly on that. But Mr. Kamaluddin is here, and it was proper to make him available. But certainly I, for my part, will not be examining Mr. Al-Nazar. I don't foresee that I will be examining him on perhaps not at all. If I am, it will be in relation to anything arising today with Mr. Gamaldeen.
Thank you very much. Well, obviously, I'm not putting an embargo on cross-examination. They have been called as a witness, but I did want to make the point that I don't see them as a witness in the normal sense. So, Mr. Iqbal, just take a moment to think of what you want to do, and let me know whether you really do want Mr. Gamaldeen, and then we will have him if you do, and see how we go.
First of all, I am in complete agreement with what your lordship said, and hence for that reason, my cross-examination shall be limited to what is said in paragraph 11 of Mr. Gamaldeen's statement, page 614, please.
614. It's okay, I got it. You get Khaled set up. Oh, sorry.
Well, I must confess that I don't regard that as having any evidentiary value before me one way or the other. So that's something that I have to decide, not him.
Absolutely fine. If it's no assistance to the judge, I won't go after that.
Well,
is to assist your lordship.
Mr. Dillon Malone, do you want to make anything of paragraph 11? You're on mute again. You're on mute.
My apologies. It seems I'm on mute when I ought not to be, and the other way around. I completely agree, and indeed the same can be said of much in Mr. Nazar's second statement in particular, that it is a question for your determination on the evidence of fact, which this is not, and having regard to the legal submissions.
Well, I think that takes care of Mr. Gamaldeen. So thank him for being available. But
thank you. I wonder, is he there on camera yet? He's not. He's just getting set up. Perhaps I will pass on your thanks to him if he doesn't come on camera now in the next minute. And we can. Here he comes.
Yes.
Now.
Hi, everyone.
Thank you very much, Khaled. We've had a discussion, and perhaps Justice Giles will explain the position.
Yes, Mr. Gamaldeen, thank you for your coming, but the result of our discussion is that no more questions are going to be asked of you. And so you are here, in a sense, unnecessarily, but thank you for coming.
Thank you.
Thank you. Might I just say then, Justice Giles, that in anticipation, we can, of course, indicate now that tomorrow Mr. Nazar will not be required.
Thank you. That is good to know also, I'm sure, for him too. All right. Well,
thank you. That concludes the evidence of the sunset parties. And we are... I would request perhaps I think we could start away certainly as planned. We've had a break quite recently. I might just signal to the court with your indulgence that because I had not anticipated going straight into cross this afternoon, I may need a break at some point just to get my material in order. But not immediately, and I wonder if that would be, if I could raise that now, perhaps maybe an hour into the cross, if we could take a break.
Yes, all right. Well, we'll see how we go, but I think we should try and use the time because, as you may gather from remarks I made much earlier, I think we may need longer for addresses than is.
Indeed. I did indicate to Mr. Iqbal that I believe if we started tomorrow, that we would, in all likelihood, finish with with the evidence on the other side by about 1 o'clock. But nonetheless, I can see we are here. I know it's late in Australia, and we're in your hands. I'm ready to start now. Equally, I think I can indicate to the court that we've had a discussion between us, and if the time were used tomorrow in the afternoon for submissions, we will complete the evidence by 1 p.m. Dubai time.
I think we should use the time. Let us call Herz, have her adopt her statements, and you give it about an hour or thereabouts, as you indicate, of your cross-examination, and we can have an early mark then.
Thank you. Thank you very much. I appreciate that.
All right. Well, thank you, Mr. Iqbal. Mrs. Herz, I take it she's in Dubai.
That's correct, my lord. Yes, she is in Dubai. Perhaps I can see that Ms. Herz is connected.
Yeah, but okay. Okay.
Okay. Now, first of all, Ms. Herz, can you hear me?
Yes, I can. And hello, everybody. Good evening, good afternoon.
Okay, now I can see that there is some feedback coming. Can I first of all suggest, if there are other people in the room, then they should mute themselves so that we do not receive the echo, and there shouldn't be any conversation in the background so that we can concentrate.
Sure.
Okay, we're still getting some echo. I wonder if it's only me or for somebody else as well. When Mrs. Herz speaks, then there is echo.
Can you shut your phone? Bend. Is it better now? No. We can hear also. No.
If there are any mobile phones which are close to this device through which you are connected, you can take them away if that might help.
Okay. I think it's better now.
Okay, fine.
Thank you.
Yes. Now, forgive me, my lord, as I understood that your lordship would wish to utilize this time by having Mrs. Herz to adopt her witness statements and make much of the time. Am I right in my understanding?
I would like the time to be used for adoption of her witness statements on oath, and then Mr. Dilmanone will start his cross-examination.
Thank you. Will somebody at the registry, can they get Miss Hana to give evidence under, well, Mrs. Herz, will you give evidence by a holy book, or would you affirm?
Any.
Perhaps if somebody at the registry can help me with.
Yes. Do you have a holy book in front of you?
No, I don't.
So can you confirm that you would be affirming today?
Yes, absolutely.
Okay, please state your full name and occupation to the record.
Full name. My name is Hana Habib Mansoor Habib Herz, and Managing Director of Pixels.
Thank you. Please repeat after me. I solemnly declare and affirm.
I solemnly declare and affirm
that the evidence I shall give will be the truth.
That the evidence I give will be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
Nothing but the truth.
Thank you.
Thank you.
Thank you. Now, before I proceed, Mrs. Herz, let me tell you something. If there is anything that you do not understand, or if the communication is not clear, please tell us. We will repeat that for us, and I will encourage you not to seek help from anybody else in the room if they can tell you what I or other people in the court have said. Do you understand that?
I fully understand.
Thank you very much. My lord, I'm referring to page 457 in the bundle. Mrs. Herz, if you can please go to page number 457.
Yes.
So, first of all, your full name is Hana Habib Mansoor Herz.
Yes.
And your address is Villa 100B, Street 6B, Al Bada, PO Box 334332, Dubai, UAE. Is that correct?
Yes, except, sorry, I have to mention that I changed villas recently to Al Manara.
Al Manara, okay, M-A-N-A-R-A?
Al Manara area, Villa 176, Street 2D.
2D as in Delta.
Yes.
Thank you very much. Okay. Now, this is the statement in front of you. First of all, can you confirm that you have read this statement?
Yes.
If you turn to page 465, that's the last page of this statement, please.
Sure.
And you can see that at the end of the page, your name and your signatures are there. Is that correct?
Correct.
Do you confirm that the facts stated in this witness statement are true?
Yes.
And you're happy to adopt this as your evidence for these proceedings, correct?
Correct.
Thank you. Furthermore, if I can refer to page number 636, please.
Yes.
This is your witness statement. You can see on the top right-hand corner, dated 4th of October, 2021.
Yes.
If you go to the last page of this statement at page number 648, please.
Yes.
And we can see that these are your signatures. Is that correct?
Absolutely correct.
And you confirm that the facts stated in this witness statement are true.
And to my best of my knowledge.
Thank you. And you are happy to adopt this too for these proceedings, correct?
Yes.
Thank you very much. Then it's a very, no, it's page number 720, please.
Yes.
Now, this is your witness statement dated 22nd July 2020. Can you see that date?
Yes, I can.
If you turn to page number 743, please.
Yes.
And you can see towards the end of the page, your name, your signatures do appear, right?
Right.
And that you confirm that the facts stated in this witness statement are true and correct to the best of your knowledge.
Yes.
And you're happy to adopt this as your evidence for these proceedings, correct? Thank you. Now, moving on, if you can see at page number 847, please.
840. Yes. It's provided to me here. Yes.
Yeah, top right-hand corner, you can see it's dated 8th of March 2021. Can you see that date?
Yes, I can.
If you turn to page number 876 in the bundle, please. Are you on page 876?
Well, she's scrolling to show me the page.
Okay.
Sorry. I see it. Yes.
Now, on the top of the page, although I can see the name, but my copy, I don't have the signatures. I wonder other members also don't have the signed copy.
Yeah, I can see the signed copy too.
You can see the signed copy.
No, I can't see the signed copy.
All right. Okay. So first of all, I want you to confirm that you have read this statement. Have you?
Yes.
And that you confirm that the contents or the facts stated in this witness statement are true and correct to the best of your knowledge.
Yes.
And that you are happy to adopt this too as your evidence for these proceedings.
Yes, I do.
Thank you.
Thank you.
My lord, regardless of the formality that there are no signatures, but she has adopted her witness statement and seeks to rely. So I would therefore, just as a formality, ask the court to waive the requirement of personally signing the witness statement.
I think it's been adopted on oath. I think that will suffice.
I'm grateful. Thank you. Mrs. Herz, now we have a fifth witness statement from you, but just 1 second, if I can tell you where that can be found. 1 second, please.
4 witnesses. The fifth one I didn't because it was very quick. Antonio submitted the fifth one, but myself I didn't.
All right. So
because I think one day before the trial of this, I'm not sure.
if I stop here, okay, if you can just make it clear, is it only the 4 witness statements you have already adopted? That's all that you want to rely upon. Is that correct?
Yes, 1859. Page 1859, you're talking about it?
That's correct, yes. That's the one that I have in front of me.
Yes.
Okay, this is headed as 4th witness statement of Hana Mansoor Habib Herz. And it is dated 25th of February, 2022. You can see that?
Yes.
You have read this statement, correct?
Yes.
Do you want to rely on this statement?
Yes.
Do you confirm that the facts stated in this witness statement are true to the best of your knowledge?
Yes.
Thank you, sir. My lord, with that, I asked the court to please treat all of these witness statements as evidence in chief of Mrs. Herz. With that, I have no further questions.
Thank you. Mrs. Alvarez, Malone, ask you questions. Thank you, Mr. Malone.
Thank you.
Thank you. Thank you, Mrs. Herz. Good afternoon.
Good afternoon.
Mrs. Herz, you're a businesswoman, isn't that right?
Yes.
Yes, and you're the managing director of Fixed Sense, which you're a 99% shareholder.
Yes.
Is that correct? Yes. And your business partner is your husband, Mr. Lutfi. Is that correct?
Not really. He only owns 1% in the Fixed Sense.
I see.
Yes.
So
I totally do all the calls. I manage the company and I do the operation.
Very good.
Yeah. Sorry. With his government position. So that's why he is not involved a lot in the company.
I see. We've seen a number of emails and communications and activity by Mr. Lutfi
Yes.
over the years. So he does have a role in Fixed Sense, isn't that right?
Actually, this emails, some of them, I have told him because I was actually under treatment.
I see.
Medical treatment, and I used to travel a lot. And I was trying to get pregnant, to make it clear, because I have sworn to be honest. So in some of them, few of them actually, I would ask my husband to please answer, because at that time we have a good friendship, relationship, and also business relationship if you're talking about Antonio and the partners.
Yes.
So husband was known to them also very closely.
I see. He is nonetheless a 1% shareholder in the business, isn't he? In Fixed Sense. Yes. And is it? Can you tell the court whether his involvement with the affairs of Fixed Sense was more active at any particular period from 2014 till now? Was there a time that you then took hold of the reins more solidly?
It is not about their time when he can and when he can. It is actually about my situation. If I was really under that medication or this, I would ask him to step in. But that's it. But
Yes.
there's no specific time for him.
Okay. Well, let me just ask you in general. During 2019,
Yes.
when I think the evidence on both sides is that there were a number of communications between Fixed Sense and the Sunset Group on
Yes.
dividend policy. Now, your husband was very involved in those communications in 2019, wasn't he?
I'll be honest, because he has a financial degree in finance, I requested his help in that area so I get things clear.
I see. That makes sense. I understand now. And then when it came to the end of July, when do you remember the 3 proposals that were put to you by Fixed Sense to try and solve your? There were. Let me take it in steps.
Yes,
In the course of 2019, you were unhappy with the dividend policy of the group.
Yes.
Yes, and then Mr. Gonzalez on the 31st of July 2019. Now, for the moment, we won't go, I promise you we'll go to the documents, or if you want me to bring you to them, I will. But I just want to just get a sense of who is active when. You may remember on the 31st of July 2019, Sunset Group put forward 3 options as to potential resolution of your unhappiness. And they said number 1 was more or less to stay with what was there under the arrangements. Number 2 was to buy you out. And I think number 3 was to buy you out entirely. And then number 2 was an additional shareholding type proposition. Do you remember those 3 options?
First of all, if you allow me,
Of course.
2.5% is my right. And this dispute happened is when I asked for my right in 2019 to check the financials. Then the option came. Antonio and Ahmed Naz, correctly, the 2 partners, visited me in my office, Business Bay. They came there to tell me, each one offered me an amount. They first offered $500,000, the other one offered me $1 million to buy my share of 2.5. This is where the dispute happened, and this is where all this happened.
I see. There's no reference in that in your statements. That's the first time we've heard about this.
No, I think I did say that they came to my office. And
yes.
And also their emails is clear. And Antonio also agreed that he visited me in the office. He told me in the office he'd come with an options.
I see. And then that discussion in the office then led to the email on the 31st of July.
If you don't like to see the email, is that okay with you?
Of course. Let me find it.
Because
this is where I'm running into trouble on my. Just give me a second, please.
Of course.
I'm sorry, I hadn't quite anticipated we'd be speaking to one another this afternoon, so I ask you to please be a little patient with me.
I'm patient, that's why I'm still surviving.
Very good, very good. Yes, on page 563, you'll see, sorry, I think it's actually on page 611. Yeah, here we go. And you'll see, this is will I just ask you to read it? And we can ask the judge to read it. It's the email from Antonio to yourself and your husband on the 31st of July.
To Marwan and myself and copy. Okay.
Yes, sure. Very good. And you see the following consultation with the board. Please see below 3 suggested options for fixed cents.
Yes.
Yes?
Yes.
And one of them is to have a current approach. Sorry, can you go back, please?
Yeah. Okay.
Yeah. And then the second is to alter the company's dividend policy.
Can I read it?
Of
Please?
course, of course. I'm trying to help.
Thank you. Oh, that's very good. Sorry about that. We would continue. Oh, okay. Can I know? Okay.
Yes, thank you. And you see the after the 3 options, there's a paragraph which says, it would be our intention in all of the above options for the current arrangement of fixed cents, providing sponsorship services to some companies' invested businesses to remain in place, along with no change to fixed cents' fixed monthly fee for such services.
Yes.
Yes. Now, what is that referring to? What did you understand that to refer to? Your existing arrangements, current arrangement.
All of the above options for the current arrangement of fixed price sponsorship services to some companies and business to remain in place, along with. Yeah, understood it as it's written.
Yes. Okay. So you accept then that it was sponsorship services that were the current arrangement at that time.
No.
Well, what else was there then?
If I may please clear something. Sponsorship arrangement can be only with individuals, not companies sponsoring anybody. What is the miscommunication between Antonio is he thinks fixed cents and Hana and Herz are one in the fact of sponsorship. I do services through fixed cents company, and this is for my services. If you're talking about the sponsorship, I was never sponsorship because I'm a partner on all the entities that I own.
But you're a partner in, I think you accept in your own evidence, in your witness statements, that you have different arrangements, as I understood your evidence to be, that you have some arrangements where fixed cents provides services, and you have some arrangements where you are a sponsor.
Yes, and I was referring to provocateur, China White, Chic, and not these, because I have built Sunset Hospitality, and I've built all the profile you've seen. So it cannot be, this is part of my life. I'm definitely a partner and not being seen as a sponsor.
I see. Well, what was your response to this email? Can you remember?
Which email?
This email we're looking at here, where he describes the 3 options for your unhappiness.
If you want, I can read it from here.
Yes.
Where is my response?
I can help you. It's on the next page. Or sorry, it's on page. Let me see. Is it 838?
Where?
No, I have the response. Excuse me. Just give me a second.
Of course.
Excuse me. I have it. 6, 7. I'm sorry about this, Judge. It's the 611. I cannot find it right now, but I think it was a short response, and I'll try and locate it. It was a short response the next day on the 1st of August, 2019, where you said, look, from now on, let's communicate through lawyers. Does that ring a bell? Do you remember doing that?
Oh, yeah. Yes.
Yeah.
Okay.
Yeah. And why did you, at this stage, then opt to only have communication from the 1st of August 2019 through lawyers on this issue, on these issues?
I'm a businesswoman, and if I find that I have a doubt in why they would not share with me the financials in order for me to take my rights, which is contractual, the 2.5. So I had to involve my lawyers because they've, Nas verbally also said that he will go to the lawyers. So it's.
But this particular proposition was relating to how henceforth your relationship might be agreed in the future, wasn't it? This particular email, and you responded by saying, "Well, please, I'm not going to deal with you anymore. I'm going to just deal with me by lawyers."
I'm sorry, no, it's not only because of this. This all started when I requested the financials, audited financials of the company, so I decide how much is the share, whether I should take the 2.5 extra and use it my contractual right or not.
Well, can we bring you we'll bring you to the shareholders agreement, and we'll just have a look at that while we're on it, because we can see the language of you've referred to your contractual rights, and the option is clause 6 of the shareholders agreement, and that's at page 512. And you'll see that there is a clause. Can you just put it up a little bit there? Yeah. You see that the clause 512, sorry.
Yes.
First of all, 6.1 is your 2.5% shareholding that you have. Isn't that correct?
I am a partner in Sunset Hospitality with 2.5%.
Yes. And then 6.2 gives you an option to subscribe and to be issued and allotted additional shares of 2.5% in an amount equal to 2.5%. And then the option periods are set out. With the first one is within 2 months of the completion of the audited accounts for the company for the 2018 financial year. Isn't that right?
Yes.
Yes. So we're talking here, when you're complaining about the not having the financials, you're talking about the 2018 audited financials. Isn't that right?
There is option B and C also. There are 3 options for me.
Yes, but in the middle of 2019, the financial year is the same as the calendar year, isn't it?
I don't know, to be honest,
Okay.
because
I
can't confirm something I'm not good at.
No worries. I'll try and keep it simple. Marwan, I'm sure, would confirm this, that we're talking about when you were having these discussions in July and August 2019, the period for your option related to the 2018 financials. Is that correct? You wanted the 2018 audited accounts.
Yes.
Yes. So it couldn't relate to the 2019 because that financial year was still going.
Yes.
Yeah. So I think there had been communications from December 2018, if I remember correctly, on the 30th of December 2018, and we can come back to this again later. The unaudited certain financials of the companies were given. Unaudited financials were then given earlier in the year. There were communications between Marwan and Fixed Sense, and Sunset in relation to those leading up to about March, but you still hadn't had the audited financials. Isn't that right?
I can't
You
remember.
still hadn't had them, even though there had been some communications, you still
Yeah.
hadn't had the audited financials. Yeah, and you were unhappy about that.
Yeah, I was unhappy about that.
Yeah, because you needed the 2018 financials in order to exercise your rights.
Yes.
Yes. And if we look at clause 6, then option A is within 2 months of the completion of the audited accounts for the company for the 2018 financial year. So you, once those accounts were adopted or communicated to you, you would have 2 months from that period to exercise the option.
Correct.
Yes. And then it goes on to say at clause 6.3 that the subscription price for the fixed cents option shares shall be calculated based on a valuation of the total issued share capital of the company at 3 times the EBITDA for the financial year.
Yes.
Yeah. And do you know what EBITDA is?
No.
Okay. Do you know what it relates to?
I know it relates to some financials.
Yes. But how would you, you're a businesswoman, how would you value a company?
I would evaluate a company by giving a specific specialist in accounts to do it for me.
Okay, very good. Understandable.
Sorry, but businesswoman, I must not be very good in financial. I
Okay,
must be good in my brains.
very good, very good. I understand, but you did understand. I mean, you signed this shareholders agreement, didn't you?
Yes.
Yes, that's your signature on page 522.
Yes.
In fact, you signed all the contracts that we're looking
did.
at in this case, haven't we? Your signature is nice and consistent. We see it right across the board. They're all signed by you, isn't that right?
Yes. Yes.
Yeah. So here, can I ask you nonetheless, because you did sign it, and I understand that you do rely on your expert advisors, and I completely appreciate that. But can you tell me, why was it that you were unhappy with the accounts that you were given on the 5th of September? Do you remember on the 5th of September 2019 you received the 2018 audited accounts?
Because I wanted all financials of Sunset Event Management, because I'm a shareholder there. They were distributing dividends or this, and they were saying that this, and I wanted to see if there was or not to confirm. And then also they take money from this company, Sunset Event. I should know where it's going, being a partner.
Okay. Are they the only reasons?
And the main reason also is I'm a partner. I'm allowed to ask for the financial anytime I want.
Yes, but the financials of this company of which you're a shareholder, isn't that right?
And also I wanted to secure how much I would have to get my shares. I cannot. Also, if they tell me today, they came with selling my 2.5 500,000. They offered. It is also in writing. How would I justify that my 2.5 is worth 500,000 dirhams if I don't see the?
Okay, let me just slow you down now here. We want to be very careful about this.
Sure.
You just told me that the reason you were unhappy with the accounts that the audited financials, I think you accept that the audited financials for 2018 were eventually provided on the 5th of September 2019. Isn't that right?
I can't remember the date.
Okay, but do you remember being unhappy with them?
Yeah, I can remember.
And yes,
of them.
and we're looking at the financial statements of Sunset Ras Al Khaimah. Yes?
But I didn't see anything. Can I see it? Can you please tell me which page so I can see?
Of course.
Thank you.
I'm sorry, this is where I'm running into trouble because I wasn't anticipating being in this detailed discussion with you now, but it's page 811.
Mr. Bill Malone, I don't want you to be in a difficulty that hampers you unduly. As you know, my interest is in leaving time for submissions.
Yes.
I will leave it to you. If you feel you are being hindered in your cross-examination, we will call now, and you can maybe it will end up being a little quicker tomorrow.
Yes, I'm very grateful. But I think Mrs. Herz has justifiably asked to be brought to this document, and I think that I might well take you up on that, because I will be faster and I'll be more deft, and it'll be easier for you also, and fairer to you, Mrs. Herz, that I'm bringing you to the documents rather than me having an open discussion with you. So the judge has. Do you understand what the judge is saying? I didn't anticipate being ready. I wasn't ready for our full engagement this afternoon. And that means I'm slower in bringing the documents to you, which isn't fair to you. And we will be quicker tomorrow if we do it that way. But you've asked to see this particular communication, and I think we should go there, and maybe we'd finish in about 10 minutes, if that's okay with the judge.
Before we end, please, sorry, can I just add one thing? The reason also, you asked me for the reason when I told you I want sunset event management, is because they were always taking the profits and invested in another. They were opening new businesses from my share, and that's why I want to clearly see where is the money going.
I see. So now you've said three things, if I can summarize. You've said, number one, you wanted to see the financials of Sunset Events, which is a different company to Sunset Rack. That's the first reason.
Let me clear something, please. I'm doing about Rack. Sunset Event Management, I hold 51% in it. Under all this companies and firms come under Sunset Event. Then they open Sunset Holding. Sunset has the chunk. This stage, all the clubs were under Sunset Event Management. And
I see. So, but you're not. You Mr. Gonzalez gave evidence this morning, and he said that you were a sponsor of Sunset Events. The 51% was held by you as a nominee, isn't that correct?
You mean the correct what I heard Gonzalo saying?
Mr. Gonzalez said that you were a nominee, a sponsor of the 51%, and that you were replaced under a power of attorney. Is he wrong about that?
Absolutely wrong about that. If you please allow me to say this. You said I'm a businesswoman, but I'm not a stupid businesswoman. That I would sign the head of agreement, which holds 51%, and then I should go and sign a nominee, which will take away my 51% holding. I did it out because of the assurance from Antonio, verbally, and in writing, saying this was a symbolic. This is to attract foreign investors so that we can open branches outside. And also, still, I didn't sign. I wasn't happy until he then sent me his lawyer's comment to give me the comfort that this will not be used.
I see. Well, we'll come back to that. But what you've just said then, you're now saying that you are an actual 51% shareholder in Sunset Events Management. Are you saying that now?
Yeah, but you're telling me also, is it a nominee? If Antonio claims that there is a nominee for Sunset Event, where is it?
I think Mr. Gonzalez referred to a court case that you brought when he exercised a power of attorney in the Dubai courts. Do you remember that?
No, it wasn't. He clearly today in his witness says that I am I'm acting as this nominee or slash sponsor. Where is it coming from?
Well, let me ask the questions, please. Do you is it the case? Is it true that you took a case before the Dubai courts where you sought to overturn the exercise of the transfer of your 51% registered shareholding in Sunset Events to another Mr. Mr. Saleh in the course of 2021? Did you bring a case or not?
No.
I see.
It was an expert case. Expert.
I see.
What a year.
And what did the expert find?
I can't remember. I'm sorry.
Okay. Well, we have it ourselves, and we have an English translation of it. So we can show it to you tomorrow, and maybe that might refresh your memory.
Well, why didn't you put it on the statement? Then I could have answered that. But
well, even though I'm not answering the questions, I will answer this one, because this is a case about black tap and brick oven. It's not a case about Sunset Event Management. Now, let me bring you to page 412, please, Mrs. Al-Herz.
Please, before we go any page, please allow me.
No, I won't. No. Unless it relates to my last question.
No, because you said this case is only related to the brick oven, and that's why I said so.
Okay.
Just stop, both of you. Stop, both.
Sure.
Thank you.
I don't want this getting out of hand. It is starting to do that.
Yeah.
We're going to spend about 10 minutes on a very limited area. Mr. Malone is going to take you to a document and ask some questions. Now, Mr. Malone will ask his questions, and he will, I hope, make them shorter than he is now.
Yes. Thank you, Justice Giles.
And listen until he's finished, and you'll answer his question, and I hope that you'll answer it quite shortly too. And he will wait until you've finished your answer before he asks the next one.
Sure.
They're the rules. Okay?
Thank you.
Yes. Right. Thank you.
Now, Mrs. Al-Herz, we had been just discussing the question of you being a very good businesswoman. And if I could ask you, please, to turn to page 412.
Yes, please.
This is the second page of the nominee agreement for Black Tap.
Yes.
And it's dated the 18th of December 2016.
Yes.
And you see under the whereas ABC, and you'll see at C, it says, the parties set out the terms and conditions upon which the nominee, that's you, isn't it?
And this one, yeah, it refers to me.
It refers to you as the nominee, isn't that right?
Fixens, please, not me. Fixens. Yes.
I'm sorry, this is a nominee agreement. Can I just turn you to the previous page? It's a nominee agreement where Black Tap, you, and Sunset.
Yes.
I see. So Fixsense is not a party to this agreement, isn't that right?
Yes.
You are personally.
Yes.
You are a party to this, yes. So the nominee in C is you, isn't that right?
Yes.
Yeah, and it says set out the terms and conditions on which the nominee assigns its beneficial and economic interest in the nominee shares to Sunset, and the terms on which he will remain as the registered owner of the nominee shares. I think he should be she there, shouldn't it?
That's what's written.
Yes. So you said, you said a few minutes ago, why would I agree to be a nominee when I'm already the registered holder of shares? But is it not the case that what's happening here is that this agreement actually governs the terms upon which you hold the shares? Isn't that correct? As in which you're registered as a shareholder?
No, this is just to help the business. And this is just for me to move on because he promised not to use it whatsoever. It is just symbolic.
I see. So we'll go to clause 2 on page 413. And you'll see it's called assignment of economic and beneficial rights and interests. Do you see that?
See, whatever.
I'm sorry, I can hear somebody in the background. Are you talking to somebody?
No, I'm telling you to close the phone. I'm not talking. I swear, I'm not talking to you.
Very good.
What
You see
I'm
it,
saying,
clause 2,
yes.
it says, the nominee hereby assigns to Sunset all economic and beneficial rights and interests with respect to the nominee shares. You see that?
Yes, I do.
Yes, and the nominee shares are the 51% shares. Isn't that right?
Yes.
Yeah. And then it goes on with clause 2.2 to say, notwithstanding the assignment and transfer of the economic beneficial rights and interests in the nominee shares pursuant to clause 2.1, the nominee shares shall continue to be registered in the name of the nominee for the purposes of compliance with the UAE Companies Law, and the provisions of clause 4 below shall apply in this respect. Do you see the reference there to the Commercial Companies Law, the UAE Companies Law?
I can see everything here.
Yes.
Please, I signed this because I was misled or misrepresented by Antonio to me.
Yes, but you agreed. I'm sorry. Please go. Please go ahead.
I will keep on saying this because I only signed it for this because of the 3 purposes. Otherwise,
Okay.
I would never sign this.
Okay. Well, let's just take a look at what it does. I'd like you to please bear with me.
Sure.
I'll bear that in mind, and we'll come back to that. But let's just take a look at what you signed up to.
Okay.
I think it'll be what this says is that the purpose of you holding the shares is to comply with the law. Does that ring a bell? I think you accept that in your witness statements, that was the purpose of these agreements.
UAE law you're talking
Yeah,
about.
the federal companies law requirement that a UAE national should hold shares.
No.
I see. Well, I understood your witness statements to recognize that was the purpose of these agreements.
Sure, I'd just like to see, can you please refer me to the page?
Yes. Mm-hmm.
Page.
I'm sorry. This is, Judge. I'm very sorry. I really am. And perhaps I can, if you just bear with me for this one, and we'll bring Mrs. Alhertz to this, and then we might leave it. I'm very sorry. It's not ideal.
That's right. We'll do that then. I think that's
Yeah.
Okay.
847 to 876. I can bring you to your first witness statement, which starts on page 457, and I'm almost certain we'll find it pretty quickly in there.
457. Okay.
457 is the beginning. This was your first witness statement that you filed on the 20th of April 2020.
Yes.
Yeah. No, it's not in there. It's in a later witness statement.
I think Mr. Dillon Maloney.
Yes, I'm terribly sorry, Judge. It's not ideal.
Well, it's also a cross-examination which is going up a few unexpected paths. I don't know whether your preparation might make it a little more focused.
Yes, indeed.
So let us try and do that.
Yes.
All right, well, so we adjourn until 10 o'clock Dubai time tomorrow. And we'll see how we go. I don't think there's anything more to be said. Anything more to be said from your part before we adjourn, Gentleman Malone?
Nothing, Justice Giles. I'm very grateful and sincere apologies. I should have anticipated that we might have been quicker today, and I apologise to everybody.
Carl, anything to raise before we adjourn?
Yes, no, I understand in the circumstances we are left perhaps with no choice except to put it off for tomorrow. If I could respectfully ask my learned friend to give an indication as to how long he might go in cross-examination tomorrow, because all I want to ensure is what time we would be reaching the submission so that I would be prepared to make submission at that time.
Number one, I don't think it's fair in what I've seen so far to ask Mr. Dillon Malone to name time. It's going to be as long as it is. The second is that you need to be prepared to make your submissions, subject to anything like people might want to say about some other course. By the time we start tomorrow, it's not going to be affected by when Mr. Dillon Malone finishes. So, Herz, I don't know whether you heard me say this to Mr. Gonzalez when we had a short break. You are now under examination, and that means that you can't talk about the case to anyone, not your lawyers, not your husband, not anyone. You may have heard me say to Mr. Gonzalez, he can talk about the weather, or he can talk about the football, or you can talk about similar innocuous subjects, but nothing about the case. Understand?
Understand, fully understand.
All right, we'll adjourn until 10 o'clock tomorrow. Thank you, everyone.
Thank you. Thank you, Judge.
Thank you.